that I've now made it back to Chadron twice in less than 9 months. So in the 45 odd times I've spoken in the last 36 weeks, you guys are still leading the pack, because I'm not counting Omaha or Lincoln. That's easy. So anyway, thanks for having us out here. As I stated, I haven't been on the job that long. I do hear from dentists from time to time, and when I do see him stop by the office, it drives me bonkers. The guy can't stop smiling. He's enjoying his retirement so much. What I thought I'd do, it's becoming an increasing issue for our office and offices across the country on trust accounting. I've got a huge presentation that I'm not going to present today. I will say that part of what you're going to see is a bigger plan that I never send letters, it doesn't seem, to Western Nebraska. You guys figure it out on trust accounts. Got most of the complaints, I will tell you, are Lancaster and Douglas County. Why, I don't know, but I'm going to figure that out. What I think we're going to implement is, in the rare event that your trust account goes negative, you will be asked more than just explain yourself, and may, depending upon the answer and the circumstances, result in what, I'm not going to say it's my brainchild, but because Denver's done it, Colorado's done it, is create a penalty box that you'll have to attend and listen to me all day long on something called Trust Account School. You'll hate it, and maybe that'll cause us not to make those mistakes again. But I thought I'd pick up a little bit where I left off last year. It seems to be of interest to people that we walk through some of the issues that we're facing at my office. We did undergo an audit by the American Bar Association. They've suggested certain things, some good, add computer software, case management software, some not so good, stop fielding calls from attorneys that ask questions about ethics. The numbers are recently released on 2014 statistics. 3 bar councils, a little misleading. John Steele's been out since December. He's battling cancer. We wish him the best. I hear from him from time to time. He still has maintained his sense of humor. But he hasn't been back since December. We do have Jane Burke in the office. She was at UPL at the Bar Association. Some of you may remember her. She's in our office part-time, and we've got approval for her to be there through the end of the year. 6,200 attorneys admitted in our state. By way of comparison, our sister state in Colorado is 40,000 licensed attorneys. And when you go visit our counsel's home office, you'll see the difference. I've kind of quipped that my office looks like going back in time to the set of Mayberry RFD. When you go to the palace that is Colorado, which I guess I'll probably be at tomorrow at a national conference in Denver, you know it. It's just unbelievable. 360 basically total complaints received, 215 dismissals. So most of the cases are going to go away, folks. So you shouldn't. It's easier said than done. I was in your shoes less than a year ago, and most of the complaints go away. So you shouldn't worry about it that much, except for reasons that I'll discuss in a minute. 100 summary dismissals. Those are done by me, basically. I just look at them and see that it's not going to go anywhere, even if what they say is true. And I dismiss it without basically even opening a file, although there would be a note of it for historic purposes if you guys were going to motion in somewhere. And then 80 were logged. Of that 360, only 80 ended up formals. These statistics are brand new. You can't see them very well, and I apologize for that, but the biggest thing is this, is that since MCLE being instituted in 2010, the total number of complaints has dropped steadily. That's not a coincidence, in my humble opinion. I think that's supported by trends nationally. We talked about this before. You're going to get that letter, and when you get it, it's going to come one of 3 or 4 different ways. Well, there will be a file that you'll never see, and that's opened as miscellaneous. May have your name in it, believe it or not, and in my office. But it's going to be a complaint that has nothing to do with the case. It's irrational. You may not have even been that person's attorney. That is opened as a miscellaneous file and is filed away, mostly for our purposes, because we want to track what I call professional complainants that are just mad at the world, anti-government types, etc. We want to track that, but it's nothing on your, quote, permanent record you don't even know about. Someone asked me yesterday, hey, I might want to see that just out of curiosity. Who's complaining about me? Well, it's supposed to be confidential, but I guess if you're the subject of it, we probably would let you see it. It's really for us just to track and send kind letters back. You need to stop contacting our office about these things. You're complaining about your dog catcher or something, or this attorney for what they did in the church. That was a good example. It had nothing to do with the practice of law. It had something to do with the parish council. This is the letter that you don't want to get, but again, take my word for this, it isn't that big a deal. That's a 9C letter that basically says even what the person said about you is true. She isn't returning my phone calls. I haven't heard from her in 2 weeks. You need to respond to me. Just please respond to me. It honestly does break my heart that the letter like this, that any decent excuse, any decent explanation, I was on vacation for 2 weeks. I told her I was going on vacation for 2 weeks. I'm sorry she's upset that I went on vacation for 2 weeks. It goes away. I then dismiss it. One thing I'm doing differently a little bit than Dennis. Dennis would just copy the letter, send it, explain yourself. I'm going to get you to the right pew in the church and say, this is all I really care about, folks. She complained about 8 things. I just want to hear about the 6th. And then once you explain it, I will dismiss it. This is the one pursuant to 9E. It's a formal grievance. The easy way to track, the only other letter you would get would be the trust account letter, and we'll talk about that in a bit. When you know it's serious, it's easy to know when it's serious because it's going to come asking for your autograph. It's going to come certified. The other letters will not come certified. Some of these we talked about. I leave this in because people do call and ask for opinions. If I can get you an answer, I will. And if I can't get it while we're talking on the phone, I'll do some research and I'll call you back. Some questions are basically changes in policy because of maybe rules changes or statutory changes, and you might ask for something deeper. If you do, you're going to have to contact the advisory committee and ask for a formal opinion. We've all read those opinions. I know you read them because you read the Nebraska Lawyer cover to cover. So I'm going to fly through some of the most recent ones because I know you've already read them. Dave Mitchell at the Yost firm in Fremont is the chair of that committee. Feel free, though. Dave didn't want to do this. He's in a commercial practice. He didn't know how his partners were going to take him volunteering, and believe me, in some respects, chairing that committee is a bit of a thankless job. People call and ask for opinions, and they're nice enough to say, you know, I just need an answer by Friday in written form, well documented, etc. Well, we have reduced the turnaround time on that from a year basically now to 6 months or less. But you're not going to get a quick response in writing. But what we do ask is that you brief it, and actually we go a step further. If you're going to go to the trouble of doing it, you should just write it in a draft opinion form so it's ready to go. Basically, I would say with the punchline that favors your position. Makes sense, doesn't it? So some of these are ones that I get most of the calls on. This kind of correlates to the trust account stuff. Never before we always said it depends, depending on the type of the case, you know, what the client's like. It's now 5 years, which comports with the rules on record keeping. 5 years, 5 years, 5 years. Put in your fee agreements that your file will be destroyed on the 5th year and 1st day, just like executions at 12:01 a.m. or as soon thereafter as it could be carried out. Get rid of that file if the client, and put in your fee agreements that the client acknowledges that that's the policy. When the case is over, it's their responsibility to get their file. If they don't get it, destroy that file. Do not keep that file, because if you do, it's like volunteering to aid at the scene, you know, the Good Shepherd, Good Samaritan law. If you keep that file, then you're still going to have some rules in place. If the client calls and says, I want it, and you say, well, I'm going to give it to you for $1,000, no, you're probably going to have to give it to them if you keep it. So destroy that file. This one is one that people didn't understand, it basically on personal injury. Well, any matter that would have a statute of limitations If the statute's about to run and you've lost contact with your client, even though your fee agreement says keep in contact with lawyer, you may have to file that lawsuit. And my advice from private practice was never let a lawsuit be dismissed on your watch. Move to withdraw, extend the date for the show cause, notify the client, your case is going to be dismissed in 90 days. I'm not your lawyer anymore. This one I can't believe, perhaps the most abused rule out there. The client's file is the client's file. The client is the boss, not you. I don't care what your fee agreement says. Get the file to the client. Easiest way to comply, give the client a copy of everything. If you provided a copy of the file to the client as the case has progressed, you have very little, if any, obligation. And I say little, if any, because the exception might be original documents. If you provided a complete copy of the file to the client during the course of the case or even after completion of the case, you have no continuing obligation to give them a second copy. If you're a good Samaritan, which we all are, you'll offer to make a copy on a disk. They're going to demand paper. You have no obligation to give them paper unless they pay for it. But if it's the client's file and they need it for continued representation, and yeah, we can be cynics, and I was in that situation, the client will quote this last sentence. The continued representation of my case, my continued representation in my case will be in jeopardy. And then I'm basically going to unfortunately tell you, you got to get the file to them. There's really no way around that. I bring this one up mostly because it's an older opinion about a mediator that was the most qualified mediator I've ever known, but he didn't want to take the time to be licensed under the Parenting Act. And an issue arose about whether he should do it. His position was, and these are my words, not his, because I've known him so long, the best, the brightest, the most experienced, talented mediator I've ever been in front of in Nebraska. And he says, I don't want to go through the trouble of being qualified under the Parenting Act. There are non-lawyers, there are disbarred lawyers who are mediating cases. I'm more qualified than they are. I don't want to have to go through the certification process. We say, unfortunately, out of respect for the law, he needs to comply with the rules, even though there was no sanction against him, nor do I think I don't think we would have proceeded, my office wouldn't have proceeded against him, but we said out of respect for the law, he shouldn't do it. Look, when you get back to your offices, I just threw this slide in. There's a 2015 UPL advisory opinion. I have to confess I didn't know UPL provided advisory opinions, but it doesn't agree 100% with our advisory opinion. It does say that non-lawyers can mediate, but that's it. My understanding, non-lawyers in the Parenting Act cases are drafting parenting plans, and this is raising a huge issue. The last time I spoke, I was asked about this opinion. I don't know where it's going to come out, if it's going to end up in the courts or not, but I just throw that out there. Yes? Oh, thank you. UPL is unauthorized practice. And it's really fired up some people. I think what happened was there was one bad apple out there that was doing it all. No relationship with an attorney. If there's an attorney relationship, an attorney supervision involved, then we're not having a problem here. The person probably could draft a parenting plan. Submit it to the attorney. Attorney says, looks good to me, I'm fine with it, and you go. But this is, people are really up in arms about this. I didn't realize it. One near and dear to my heart, it comes out of Kentucky. It was my practice just up until last September when I took this position. Plea agreements in federal court required bad attorney waivers. You waived ineffective assistance of counsel and rights to appeal in most every instance. The Supreme Court of Kentucky adopted the advisory committee opinion, said you can't have bad attorney waivers in your plea agreements. Nebraska was enforcing this. We've said don't do it anymore. And I thought there would be a lot of fallout from that, but there wasn't. Yes. And it's part of the plea negotiation now. I think rights to post-conviction and you can't, the fact is you never could have waived it anyway. As in the federal setting, that 2254 instance of appeal, it was in there that, and most of us know, in plea agreements, in a plea situation, you're waiving most every right anyway, but you can't waive your right to ineffective assistance. But the right to appeal itself, in most circumstances, you're waiving it most of the time anyway. I talked to Judge Kuper at length about this, but he's like, if you're practicing in federal court, you have the right to negotiate. You are getting a better deal under a plea scenario. I don't know what like I said, there hasn't been a lot of fallout. I just know that they're not including it in writing, but I know the Eighth Circuit is basically treating it as if you're waiving your right to appeal in most every issue that you would raise other than ineffective assistance, or the fact that the crime you pled to is no longer a crime as determined by Congress, which never happens. Oh, sorry. Question was whether the waiver included, if that has barred a waiver of a right to appeal in a criminal appeal. Technically, I think the advisory opinion says that, but I don't think in reality that's possible, because a criminal defendant pleading guilty is, just by pleading guilty, waiving most of his or her rights to appeal. This is a new one from this year, transitioning attorneys. It's happening more and more, as some of us discussed earlier. Fact is, at least on the east side of the state, when there's a lot more specialization, you guys are more broad-based in your practice. If an attorney specializes in probate only and is not involved in litigation, she can move over to opposing firm in a case as long as she's screened, has nothing to do with the case, had no involvement. Burden is on transitioning attorney to say, I came over, I did nothing but probate. I didn't work with the litigation department. I had nothing to do with that case. Burden shifts. Now I produced a brief that she wrote on this case 10 years ago. And this was about a case that is still in litigation. I know I'll shock you by this. 2 Omaha firms. Over a dozen years. And it's still going. It's been to the Court of Appeals fourth time. Okay, county attorney elected in one county. Could that part-time county attorney be a guardian ad litem in another county? And the answer is no, because you're representing the state, nor can the other members of the firm. But because the whole premise behind this advisory opinion is the state can't waive a conflict. But you could be a GAL in private civil cases where the state of Nebraska is not a party. That's the gist of 1502. And I think this is 1503. Oh yeah, this is a former part-time county attorney becomes part-time public defender. And I think I'm out west now. You guys are probably figuring out exactly who this is. But the big question was, is that a conflict? And really, we talked about it. And Judge Hippie weighed in on this greatly, and it was unbelievable, his perspective on this. It's a two-way street. You know, the county attorney, aggressive, going after this person, probably called her names at trial, said she was terrible, horrible, and then says 5 years later, and everybody in the community knows she's a really tough prosecutor, and 5 years later, Mr. Defendant walks in the office, and there's the former prosecutor. She's now her lawyer. Well, it's a twofold deal. If the attorney doesn't feel she can do it, she needs to get out or assign it to her deputy. But the bigger issue, and I couldn't agree with Judge Hippie more, is think about the poor client. She's in this precarious situation that there's a fundamental lack of trust at this point, I would think. And if she has any inkling, inconvenience whatsoever, that attorney and her office should not be involved. Big one coming up, the proposed rules for GALs. There are a couple of GALs in Douglas that, in my opinion, might have ruined it for everybody. Billing 12 hours a day on a case, billing on behalf of the mom and the ward on the same case. It's really kind of sad, but we have an outstanding advisory opinion request on that. This is a big one for smaller communities. Could 2 firms ethically screen and share an associate? There's not enough work to go around. That one's sitting out there. Should come out to a jurisdiction near you in the next year. and then a bigger issue that we could do a whole hour on, and that's the duty to report diminished capacity of one of our partners. Things like early onset dementia, etc. This is kind of the beginning. You guys are the guinea pigs. This are another 60 slides here, and for the same reasons that I drove court reporters crazy and in trial, I tend to fly. I'll make these materials available in some respects, but it is a work in progress. I was going to present just this alone, but I thought it was of some value to get through some of those advisory opinions and also the procedures in our office. Some of this is pretty standard. Some of it you'll be amazed. I'll try to recall some of the examples that I've faced here in the last 8-9 months that I just can't believe. I should back up and say I was in private practice for almost 30 years. Started out in an insurance defense firm. I did a lot of work for State Farm. About halfway through my career, as Joe McQuillan would say, I went to the dark side and I chased ambulances, did a lot of mass tort stuff. So I've looked at it from both sides. I did a lot. My true love was criminal defense, including a lot of work on capital cases, a lot of cash practice in the criminal defense day to day. I got very comfortable standing at the rotunda of Douglas County Courthouse receiving cash from clients. Never gave it a thought of what people might think that looked like. But I always had that mindset, and I think it went back to just that old standard firm. Everything that we did with money went through trust. There's so many exceptions to it. But I say to you, I challenge you, why would you want to do that? Why would you want to say, well, I only bill after the work's done, and it's basically one client, and if that's the case, God bless you, that pays all my bills, and I don't worry. I just send the bill and it gets paid. No, you don't have to run that through trust. I would. I would for any number of reasons. I keep time on personal injury cases. Part of my training in the criminal practice and insurance defense. You know, it's Chevy Chase from Caddyshack. You know, you don't keep score. How do you measure yourself? And he said by height. You know, in writing your time down as a young lawyer, you will determine whether you're efficient. Hey, I made a lot of money on that slip and fall. Did you? Look at your time and you see that you lost your butt, that your time exceeded what you recovered. So that provides me with a little bit of a background. I happen to think, since I was in private practice all that time and had a diverse practice, that I understand the agony of what we go through day to day in these cases. And clients that are upset that they don't have their money, it's their money right away. It's not the chiropractor's money, it's their money. So bear with me on some of these. I do have some pretty strong opinions. You got two accounts, the trust account and the office account. That's pretty simple. Office accounts for earned fees. Example pops into my head. Why was your trust account negative, and why was that retainer in your regular account for a week? Well, it's my practice. I'm so worried about bouncing a check in trust that I always put the initial retainer check in my operating account to make sure it clears. Don't do that. Don't do that. If the client gives you a check for a retainer and it bounces, I send you a trust account letter. Explain yourself. Client gave me bad funds. That's the end of it. It's closed. Don't run it in your trust account, forget about it. Oh, I earned the fees, now I pull it out, and it's never touched the trust account. Client complains, then we discover it. I think it's a bigger problem. Advance fees, advance expenses, or any other fees that are entrusted to you, whether you're an escrow, mom gives the money, and that's an issue we'll address here too. 3 accounts. You got your trust account, the office account, and the personal account. What's interesting is I see in smaller communities, the banks are funny. They're so nervous because they got to fill out this trust account affidavit. They swear that they'll let me know if you guys go negative. And I get the same statement, similar statements, not the same, from the same little bank for the same small firm that gives me the attorney's personal bank account info, you know, the Quickie Mart, you know, bought bread, etc., and groceries, gas. and then I see the trust account stuff. I tell them, don't send me that. I don't need to see. Oh no, we're required by rule. Well, all right. I guess better I got the information than I didn't. I would suggest not confusing these three accounts if you can. I understand that personal and office, it's not any big deal. I'm not going to care about it, but I just think it'd be better office practice to keep them separate. Interestingly, you don't have to have an IOLTA account. I just think it's easier because they do the accounting for you. You can opt out, and the rules provide for ways that you can opt out. Again, you don't have to have a trust account whatsoever. If all you do is a bankruptcy practice, and it's all billed after the fact, you don't have to run it through trust. They're earned fees. Some people enjoy the fact that they don't have to have a trust account. The exception on the IOLTA that I would suggest to you is if you're going to handle large sums of money, if you're doing a lot of farming closings and there's a huge chunk of money sitting in your account, that's the client's money. The IOLTA idea was just this nominal amount. We were tired of it going to banks. It should go somewhere, and of course now with IOLTA it's a great idea because it's going to help indigent practice and other services for the poor, give them access to justice. But if it's a huge amount and it sits there longer than you anticipated, that money needs to go back to the client. And there'll be some conflicts that we'll talk about there. Commingling happens more than you know. And commingling can occur in a simple situation where you bounce that check because you gave it to the client too quick and the insurance company didn't honor it, or the bank didn't honor the insurance company's check soon enough. Well, that client is outspending your other client's money, really. And so, yes, it's the client's money. In a perfect world, I attended a conference in Las Vegas, and it was really pie in the sky at the end of my ambulance chaser days on a mass tort litigation. It was a conference, Mass Torts Made Perfect. And they had these big wigs come in, big money, and it was at the in Vegas. And attorney comes out and said they helped establish a bank established by lawyers because they know lawyers. Seemed pretty slick to me. But anyway, the idea was that if you're still writing checks to your clients, you're not doing them a favor. And the more I listened to it, it started to make sense. We're holding on to that client's money, waiting for our bank to decide when to honor that check. Why wouldn't we just fund with an electronic funds transfer? The insurance company shoots the funds there, and we give our client that pre-funded debit card with her money on it. Especially comes in the case when we're representing immigrant, potentially illegal immigrant clients who are legitimately hurt and entitled to money. That's their money. They can't open a bank account. They can't cash that check. So I think it's coming to the future here, in the near future, that we're going to be doing electronic funds transfers, and that money will be readily available. And I saw one of the first trust account letters I sent out. It was a bounce of a $550,000 check. I can't imagine what the fees. I probably do know what the fees were, but I've forgotten. I did send a letter, and I don't suppose it was met with any humor. Well, first of all, congratulations on what appears to have been a really nice settlement. But secondly, explain why you bounced a check of that magnitude. Commingling can occur two ways. You put your money in the trust account with client funds, or, unfortunately, you put client funds in your office account before they're earned. Hypothetical number one, and this is common, more common than I guess I realized. Attorney's worried, I don't want to bounce a check in my trust account, so I'm just going to keep $500 in there. And other people have raised the true scenario that a bank won't let you open a trust account without putting some money in there. Well, $500 is a little steep. I say probably not. I think, Kent Froesch has said, somewhere between $50 and $100. If you a client called or attorney called and was keeping $5,000 from a settlement in trust just for a rainy day, and I had to tell him to get it the heck out of there because that was commingling. We know the banks charge fees, and like one bounced because she ordered more checks had very little money in there and ended up getting a fee, went negative. So, you know, you can make sure there's a little bit of a cushion, but not by much. And you're not going to get any trouble with me on something like that. I ordered checks and I went negative. Some people are real good about keeping their trust account zeroed out on a monthly basis, which is a gift if you have that type of practice. That's the one, probably the scenario about the $5,000. You receive an inheritance, you're afraid of where it might go, so you decide, if I put it in my trust account, I'll be less likely to touch it. You guys know better on that. Don't do that. Yeah, it doesn't make any difference. One we were talking in our Marriott Caravan West was one that I've been facing, and it was an attorney disciplined for commingling, and seriously disciplined. And I got a trust account notification, and I looked at it closely because I recognized that attorney had been disciplined previously. And what had happened was that the attorney had attempted to make a car payment out of the trust account, but there weren't enough funds in there, so it wasn't honored. And the attorney, because that attorney had been in trouble before, had maintained a relationship with that attorney's representative, who contacted me and said, well, that's not a violation really when you think about it. And this is a pretty seasoned veteran of defending people with complaints in my office. The bank didn't allow the transaction to take place. It was never consummated. He just tried to. Thank God there weren't funds in there because he wasn't allowed to make that payment. And that was supposed to be an absolution of his conduct. Don't do that. One unfortunate thing about my business, when I talk about things like this, I have to identify attorneys by name, and this was unearned retainers into business account was a violation of Rule 1.15. And again, if there's a question, please run it. I don't know why you wouldn't anyway, even if it's for a second. Hand the check to the bookkeeper, put it in trust, and then issue a check to the operating account for my fees. Why not? It's an extra step, but I think it's worth it. You should disperse funds on a regular basis. Bill at a regular cycle, I suggest 30 days. Obviously, you can do it more often. And if those funds are sitting there, and that's another common question I get, people wrapping up practice, people selling practice, people passing, and their representatives come forward. We've got $359.60 in the trust account. We have no idea whose money that is. I'm not prosecuting that. I don't think we ever have. Number one, I'm not prosecuting because it's probably your money, and you forgot. I'm terrified to think that the audit ability that I have, I wonder how many firms, if I went and audited today, including your own, would they zero out? And I would suggest I doubt it. But the answer to the question, what do you do? Pretty simple. You make all reasonable efforts to account. You make all reasonable efforts once you have accounted that you know it's Joe Blow's money to contact Joe. If you can't make contact with Joe, then you send it off to the state treasurer's unclaimed property, document it, get it the heck out of your trust account, and feel like you've received absolution and your account balances out. You'll feel so much better. You know, again, it was my own practice. I always did a settlement statement in my personal injury cases, just blow by blow of what came in, what went to the fee, what went in expenses, what went to the liens, and the liens we're going to talk about a little bit here, time permitting. And then have the client sign off. I included an indemnity provision just because I was a nervous guy that said, I've read the above, and those are all the providers to the best of my knowledge. And further, I indemnify and hold Mark Weber and Walentine O'Toole harmless in the event there are future claims. Who knows if that's enforceable, but it sure sends the message to the client, gee, maybe I should have told him about the other provider that I thought I'd get more money by not saying anything. I think it's better to have something like that You represent the seller in a real estate transaction, the buyer gives you 50 grand. You put it in a non-IOLTA account, which is the smart thing to do because there may be a lot of money, interest earned on that. And that's why, because of the money you might have to get back to the person who gave it to you. And then buyer gives lawyer $50,000 check for the earnest. Lawyer puts check in separate account. The deal doesn't close. Buyer says, give me the money back. Client says, no, give it to me. And that happens, as you guys know, quite a bit. Well, you just put yourself out there in a position that you're possibly representing both. Your fiduciary relationship is both to the client and the other party. And try to resolve it. And if not, you're going to have to pay those funds into court and let a court decide. Yes. Sure.
Is it all right when you send them, just send a letter and say, if you keep a ledger, paper ledger, you say, what's in the ledger sheet showing the expenditures, and is that sufficient? Actual letter to sign.
Oh, I think there was a question here live about whether you need to send a written explanation as opposed to the actual ledger that shows the account being closed out. I think that that's even perhaps better, to just send the ledger showing that it's zeroed out and that everybody's been taken care of. So no, I'm not suggesting at all that those are the rules. My suggestion was probably a little more overkill, especially in the personal injury setting when there might be 3 or 4 different payees on one settlement draft. Crawford, there were many reasons for the disbarment in that case, but there was a deposit of unearned fees into the regular account. In Crawford, the attorney was upset because it was originally just somewhat of an innocuous complaint about attorney conduct. And the attorney was very slow. You read the facts in that case about responding to our office's inquiry, which I'd suggest you don't take that approach. If you are freaking out about it and you don't have information and you want more time, I'm going to give you more time. But don't ignore my office. I should have said back before, even the 9C, when I say it's no big deal, give me any explanation. Failure to respond to a 9C inquiry from me is grounds enough to elevate it to a formal grievance. So don't buy trouble. But the gist of that is the underlying portion, which says, you know, we don't care what caused the initiation of the investigation. We uncovered things about funny business in the trust account that caused us to go down that line. This was before my time, but that is ultimately what brought that attorney into really big trouble with the court. Criminal case, mom gives money, the attorney does no work, and this is more common than I can believe, although as a young lawyer I had older attorneys ask me about that. But again, because of my insurance defense practice, I always put that money in trust, that cash, whoever gave it, mom or the client themselves. The older attorneys said, no, that's my fee. That's a non-refundable fee. I'd suggest to you that the non-refundable flat fee is about the same as a unicorn. It doesn't exist. If you don't deliver, if you deliver the product, and 90% of the time you're going to deliver the product, you're going to take care of that second offense DUI for $2,500, which I think was the going rate in Douglas County when I stopped. But if you don't, and you know what, you don't have to put that money in trust. I'm good with that. I think it's bad practice, but I'm perfectly fine. You will not be prosecuted for that. Once it's earned, you put it in your pocket. But the attorney says, no, that's a non-refundable flat fee. I don't care what happens. Client gives it to me that morning. I'm out buying dinner with my wife that night with that money. No. Now, I've had the question arise when someone sells their practice. It's an immigration practice. Standard fee in Omaha for whatever widget is being delivered in the immigration practice, $4,000. Attorney 99% of the time is going to earn that. At some stage in the litigation, the proceedings, I should say, attorney transfers $2,500, then $3,000, then $3,500, then $4,000 into the operating account and spends it. The one less than 10% of the time, It doesn't get delivered. The case isn't done. The attorney sells the practice, moves on. Client's sitting there holding the bag. Money's gone. Who's going to finish that work? Well, the attorney that made that deal has got the decision to make. You either refund a part of that money to allow who remains to complete the work, or you do the work yourself, presumably, if you're keeping your time accurately, at a loss. But you cannot expect the client to pay for the completion of the services. That's why I don't like the non-refundable flat fee idea, because I don't think it exists. You haven't earned the fees, you can't put it in operating account, put it in trust. Now, on this disbursement of flat fees, the people that do proceed in that, I would suggest if it's a similar type of practice, the DUI, I figure there are three things. In the old days, you'd have the ALR, you'd have the arraignment, then you'd have the plea in most DUI cases. Well, you don't even have the ALR anymore, so you got two real big stages. You got the arraignment at which you could enter into your plea agreement, then you have your trial, at which time you're either going to go to trial or then enter into your plea agreement. You could set it up where 50% of the fee is earned after the arraignment and the balance at the time of trial, or in the event of a plea at arraignment, you take it all. But you should really have that set out so you can show to the client that you've earned it. Again, I kept time in those cases. Even if I charged the $2,500, I kept time because I wanted to ensure that A, I was making money, so I didn't either have to hike my fee agreement or get out of doing that DUI work. But also, if the client fired me and wanted a refund, I would have documentation of what I did to justify why I wasn't giving them all of their $2,500 back, maybe less than $500. Oh, that's a nice note that just, you know, you can put down that you're worth, and I'm sure you are, $1,000 an hour. But if you're billing $1,000 an hour on a simple DUI, that doesn't mean just because you told the client that was the fee that that's reasonable, if that makes sense. And also the confidentiality rule would apply. Mom gives you money. Just because mom gives you money doesn't mean you have to talk to mom about the case. Just good practice, I think, is to say to son, I assume I can talk to mom. You're waiving any rights on that, so I can tell mom what's going on since she's footing the bill. This is the one that, well, this is, we'll get to, there's another one here, but this, settle a case, get a check for $100,000, which is basically made out to you and the client generally, but you advance $3,000 in costs, and it's made out to you and the client. Can you deposit it all in trust, even though the fees are earned? And the practice is yes, you want to put that in trust, and the reason for that is invariably in that type of practice, you get a good settlement, the client's going to determine that you didn't earn those fees, and there may be a dispute. The other reason to keep your time on personal injury is if there is a dispute, you probably have more of a justification to deposit at least some of the fees into your operating account when you've earned them on an hourly basis. The rest of it, of course, will be upheld if you had to take it to court, to have the judge tell the client that you're entitled to your third, because that's the agreement the client signed. That's the other thing. I mean, you feel for their clients. I touched on this earlier. You want them to get their money. They're begging you for the check. Oh, I won't deposit it until you tell me. And one real-life example, the first thing the client did is left the meeting and ran to the bank and threw the check in, and it bounced. So you really have to be kind of tough on the client on that one and not release it until you know that those funds are going to clear, because if you don't, many attorneys have skated on this because they have plenty of money in their trust account. But if you don't, well, even if you don't get caught on it, you technically are commingling. This is the one that is going to get me crosswise with my pals at NADA because it's becoming a bigger issue. The attorneys are upset, saying it's not my job to do the work for the lien holders. I can't imagine a case where I had a letter, and the argument goes something like this. The lien statute is for the provider to do the work and get the notice to the insurer to perfect the lien. I don't care if I get a letter. That's not a perfected lien. That's just a letter from a provider to the attorney. And that is how it was explained to me by someone that I asked to explain to me how they thought they could do this. Client says, oh, don't you dare pay that chiropractor. Don't you dare. That's my money. I'll take care of it. And that check is made out to only you and the client, not to that particular provider. But the attorney is aware of 4 providers. One of them happened to be left off. The insurance company missed it. Client says, don't pay. The worst thing you can do is give all the money to the client. Again, my friends at NADA, there are a few that are not in agreement with me on this. I just don't know how you get around it. I really don't. My suggestion to this attorney was that they ask for an advisory opinion on it about what to do if you're on notice of that claim, even though that provider's name was not on the check. If the provider's name's on the check and you're endorsing the provider's, using the provider's name and somehow endorsing the check in that provider's name, I think you got other issues. But I don't know how you can justify, either by some quirk around the statute, it's not a real lien, because the lien isn't perfected with the lawyer, the lien's perfected with the insurer. I think it's a problem. And it's one of those that I say, if you request an advisory opinion on it, and the attorney didn't want to, and I suggest, I happen to think I know why, because he didn't want to see the answer. So that's becoming a bigger deal. I've got several of those on my desk as we speak. And that's the reason why, 1.15E. It's right there in the rules. When you have knowledge that someone else claims a right to that money, you may not move it. It needs to sit in trust until you've resolved it. Now, I would say, and I would say you agree whether perfected or not. If I receive a notice of a claim from any provider that is just corroborated by the records, it's not a fake provider, some claiming some right to proceeds, that you have to honor it. I think that's probably best practice. It's certainly the best way to cover your tail. I just feel bad. These are good lawyers that work really hard, but the response I got in writing was, I have an ethical obligation to my client to give them that money.
We had a situation come up where we had a provider, a hospital, and I was dealing with the hospital, and then here comes a credit collection company. Is my ethical obligation only to the hospital and not to the collection company?
So the hospital bill was reduced to collection.
It was sent out for collection. I did not know that, but I was dealing with the hospital themselves negotiating their lien, and got it done, sent them check, and then, like 2 months later, here comes a collection agency that then is trying to collect the same bill.
For the same debt?
Yes.
I think and I didn't get into that. We can ask young Joel Carney on that issue. That's more of a debtor-creditor issue, but I think if you resolved it with the main provider, I think you've resolved it. And you'd use that as a defense to collection agency who's trying to double dip, in my opinion.
Okay, so my obligation is only to the underlying provider?
I think so. That's the way I would treat it in my office. I would say, they'd call me and say, oh, I'm upset, that was our debt. So that's a matter for civil court, it's not an ethical issue. That's how I'd address it. Is there another question? Oh, should I have repeated that? Sorry again for our friends participating online. The question was, what happens if you resolve the debt with a third-party provider, the hospital, and in the meantime, or maybe prior to that, the debt had been transferred into collection? My issue, as I look at it from my perspective, it's only the ethical issue is with the provider, not an ethical issue with debt collector, and I would not pursue any ethics violation against that attorney for refusing to do anything with the credit company and defer their complaint to civil court. This one is a little bit different. You've got $1,300 left, and the client doesn't think you have anything common. Well, the client thinks you have $300. Well, if the client agrees to $300, I get that in writing, number one. You could at least take your $300. And then you have your bill that shows you actually had $2,700 worth of billable time on it, and that's what your fee agreement allowed you to get. It doesn't really matter what the client thinks. I think most courts are going to back you, and you're going to get that money. I had a case. The complaint was I didn't get the money back. That lawyer did nothing for me on that divorce, and that was lawyer number 2 of 3, probably 4 by now. And the attorney was so nice. She helped wrap up the case in terms of getting the file prepared, getting out of the case, providing the file to the other attorney. Didn't write any of that time down, and there was $1,200-1,300 in the account, and the firm just had a policy of writing the bill up. And everybody's heard of write-ups. I was involved in firms that did write-ups all the time. Write it up and close it. In a flat fee scenario, you delivered the widget, you did it most efficiently, you did it within an hour of being retained, boy, you're good, and you've earned that fee, because that's what your fee agreement says. But if you say you're going to deliver the divorce, and it's a flat, non-refundable $20,000, and for whatever reason, it was client's fault, client fired him, you can't write that time up. And but I'm also not going to let you guys be held hostage on an ethics complaint. They made good faith efforts to resolve it and offered most of the money back. I admonished that attorney. I said, if you would have kept your time, I wouldn't have even responded to this. I would have summarily dismissed the complaint because your time exceeded the deal. And they approached complainant. The complainant was actually the dad who was paying the money, who had also been divorced 2-3 times. So they just hated the system. And they offered 99% of it back. And they said, no, since you've come and offered, go figure. They wanted the entire retainer returned. And I dismissed. I said, I'm not going to be part of this. It's a civil matter. Go about your business, and we're not going to have any part of it. You need to account. You all know that, and you do it, so that's not really an issue. This is when the attorney gets disbarred because Rasmussen's client asked for an accounting. Attorney refused. There was really no explanation for not providing an accounting. 10 minutes? See, I just asked the minutes. I didn't ask which time zone we were in. Liz will explain that later. Okay. I'm actually moving along here. Trust account bookkeeping, that's getting toward the end. Safekeeping property. I had an interesting scenario, and maybe it was one of you in the audience, that a court ordered documents to be produced in some case, but it was during discovery, and ordered that the documents be destroyed within 30 days. Now, I've never been involved in litigation where it's like something out of Mission Impossible. And Stick's young associate was calling me and says, hey, my attorney would like to use 1.15 to say to the judge, I can't destroy it now because that document is now client property, and we must keep it for 5 years. I said, wow, I don't know. I don't think that's an ethical question. I think you should go to the judge that told you to destroy it after 30 and explain to the judge why you think it now falls under a client's property. I haven't heard back from him. Keep records of each client, source of all funds, records about all funds, and whoever was distributed money, and reconciliation says do it quarterly. Someone that was on the advisory committee got up at the Bar Association, talked about how he just got bled dry by someone that I think he and his wife sponsored the bookkeeper's wedding, spent a lot of money and found out later she embezzled tens of thousands of dollars. A good way to avoid getting in trouble there is to reconcile more than every 30 days. Simple things. Trust account checks have them different than office account checks. different numbering sequence. You know, you don't get the canceled checks anymore, but you can certainly get copies, and that would be a good backup for your bookkeeping. And make sure as often as you can to keep it in balance. Someone called, said their bookkeeping software was outdated, the computer wouldn't accommodate it anymore. I think easy programs like Quicken or QuickBooks, that's something that is still printable, that allows you to print checks too in these modern times. Just moving right along. Yeah, you can't assume just because you're off $100 that it's one error. It could be two or more. And also don't assume that your bank hasn't made a mistake. I had not a retired, but an attorney sold her practice, was vacationing, dipping her toes in the sand, and her banker, who she knew very well, called her on her cell and said, you're on 4 checks and counting bouncing out of your old trust account. And it just ruined her vacation. And she called me and she was sobbing. It's funny now. It wasn't then. You know, I told her to relax, number one. I mean, no reason to believe she was stealing that money. And it turned out it was a bank error. And you know, they apologized, and, you know, like banks, so, gee, sorry, was that a big deal? Yeah, it could be. But, you know, I get those all the time. You know, I'm like, the bank will own up to it. Keep all these things. Keep copies of fee agreements. And now, because of that earlier advisory opinion, it comes in line with the rules. And keep a signed copy of the fee agreement, because you don't want to get into the situation where the client says, you know, gosh, I don't remember signing that. You should always review the statement. It may not be practical in bigger firms, but a lawyer should look at the statement, then give it to the bookkeeper, not the other way around. But in any event, the lawyer should look at it at some point in the process. And yeah, only disperse what that client has available at the time. You can't say, well, I'll give you another $300-400 because the second check is coming next week. Cash receipts, especially those of us that were doing, you know, people practice, especially criminal defense, and keep a cash receipts journal. And this is what we talked about. It goes hand in hand now. 1.15a, you got to keep those financial records for 5 years. It's pretty convenient. I can't say, even as past chair of the advisory committee, whether that was what was behind the records retention. But now it's pretty simple for us, right? We just say 5 years and we get rid of everything. Financial records, I totally understand if you're going to keep them longer than that. And that is the rule that we talked about earlier, 1.16d. You can get in trouble. You can't blame your staff for your own shortcomings. You can hire good staff, that's a good start, but you really do need to monitor what they're doing. And you can't delegate, and you can't hide. And this is good ethical advice for other than just trust accounts. If you're the managing partner, if you're the sole practitioner, you're in charge of following the rules yourself, but you're in charge of ensuring that everybody in your office, even your investigators, your law clerks, your runner, complies with the rules. And lack of supervision. Blamed it on as a bookkeeper. It wasn't my fault. I thought she was doing it, and I found out later she wasn't. And Stratmore got in trouble. Statmore. We're coming close to the end here. Yeah, get references on your bookkeepers and be involved. Easier said than done. I always hung around partners that were gifted, talented in that area. Seriously, I was escorted out of the School of Business at Creighton. And it was a good thing because I wouldn't be here today. Over to Liberal Arts College where I belonged. I had no idea what I was doing, and I knew that going forward in my law practice. Some of these, again, this is a work in progress, but hopefully touched on some things that you are going to chew on. The biggest thing is probably that fight with personal injury attorneys on what exactly to do. I guess I was just blessed that I never ever paid money to a client that if there was a colorable claim out there We resolved it. It was paid. It was resolved then. And I don't know why you'd put yourself in that situation to be the judge, to say, I've determined that that's not valid. I'll trust my client to take care of it. You're going to end up explaining stuff to my office, I'm afraid, if you don't do it that way. So thanks for having me out here, and see you again soon. Yes? I will. I don't want to make them online because they are a work in progress, but if you call and ask for what I presented today, I will. It's not the complete deal. The one I'm working on is almost 100 slides now. And if you have a negative balance in your trust account, you'll get to see them again because I'll make you attend trust account school. That was a joke. I'm not necessarily doing that. Yes, sir.
What about offices that have client files back to the late 50s? And I mean, it's a huge problem, and it's very easy to discern, what's been within the past 5, 7, 8 years. But some of these are nearly 60 years old. Can you just dump them, or do you have to try to contact those people? Maybe at night you're trying to trace, and it's not like it's one box, it's a base.
What I'd suggest, okay. There was a question about client files being retained and what happens in the event that the attorney has kept files back 50 years and counting. There is no easy answer, I suppose. I'd like to say just destroy them, and in that respect I'd say shred them or watch the bonfire to know that they've gone up. But I would document. We had one where an attorney retired 4 years ago, died 4 months ago. Most of the files are beyond the 5-year. Family wants to know what to do because those files are stored in his basement. We don't want to get in a situation where at every drop of a hat we're appointing a trustee. I'm actually tasked with creating a rule that comports with other states that say when there is no partner, no other attorney, no personal representative, or no other reliable family member or other person, files, maybe you need to ask for a trustee to be appointed. The thought process being someone in a position of making a decision. If you're a surviving partner in that firm, you make the decision. I would document a letter to me. I would then forward that to the chief. That goes to the court. They could also say, unless we hear from you, we're going to destroy them January 1st. We're going to have a big bonfire. I think that's the best practice. The process is only going to increase as we age and these files are left to rot. We're trying to come up with an idea of how to transition. In that case, it's stuff in the basement. That's why I say destroy, 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 because if you don't, you're in that situation. Now what do I do? I can tell you right now, the court isn't going to appoint a trustee to go through these files from 50 years old looking for the Magna Carta copy. It's just not, we're not going to do it. We're not going to spend that money. So I would say you're pretty well justified in destroying those files, but as long as you document and say this is a plan. We're going to start phasing these out. I would almost work backward. The newer files, if you can't reach the client, you get rid of it, 5 years, and then keep going, and then let the court know that's it. Just have a system in place. They're not going to question you on that. Neither will I. Any other questions? All right, I think it's time. Who do we get now? Oh, our executive director, yay.
Why don't we just take a few minutes for the transition so you guys can refill your coffee for the rest of the
Does she need clicker? Okay. Yeah.
I'm sorry.
Oh, no, we're leaving it here.
Yeah. I just want to make sure that.
I just want to say it's, well, I think it's good.
still have those documents.
You gotta restate it.
Right. Right.
Right. And it's just, and then one last question. This has to be can the attorney qualifies to do so?
Yes.
Right. Or somebody doesn't.
Well, yeah. That's what I tell them to do. And actually go to the best defense office and say, he's not doing his part of the service with that. Yeah, and when we have it, so we know and you say the client says no, and you get to trial. That's a problem, and I had somebody call me. Said, experiencing it every day. That this is I've seen that too, because I did a lot of defense work. Not really, don't want to do it, dismiss and then refile.
Well, no, I think it's for 2 weeks before trial. Say, Judge, I found that
That's a reason.
But can the client wait?
Yeah.
Right, that was the position I had. Okay, I don't want to keep
That's
it.
It takes a little bit more. All right. Good morning, everyone. My name is Liz Neeley. I am the new Executive Director of the Nebraska State Bar Association. This morning, though, we're going to be talking about research and policy reform in Nebraska related to racial and ethnic fairness in our court system. And for those of you that are in Chadron participating in person, you'll notice that you have a fun little remote control. And I think this just makes things more interesting. We like to poll people, quiz them throughout the presentation. If you feel a slight electric shock when you get a bad answer, don't worry, it's not life-threatening, it will cause no permanent damage. To turn this on, you want to push the bottom middle button, the one that says O/J. And so that will activate your clicker. And we're going to do a couple of test run questions just to make sure you're comfortable with using this. Is the clicker? Is there a... Geez, Mark. No, I'm just kidding. I can, if you want to just flip this around, I'll just push it. Oh. Did it fall? It fell asleep. Okay. So just to kind of test this out, I'm going to give you kind of a couple of practice questions. Your first practice question is, how familiar are you with the Minority Justice Committee? So if you're very familiar, you would click A. If you're familiar, you'd click B. If you're somewhat familiar, C. If you've never heard of it, click D. That's going to tell us how many of you responded, and then we'll post the results. So we have some people, a few people very familiar, most of you somewhat familiar, and about a fourth of you never heard of the committee. So this will be kind of a new information for that group. So here's our second question. It is important that Nebraska's justice system is perceived as fair and accessible. Click A if you strongly agree with that statement. Click B if you agree. Click C if you disagree. Click D if you strongly disagree. This would be a great time for me to mention that your answers are anonymous, so I will never know if you think that this is not important at all, if the committee is not important, if this issue is not important. I will not be able to look at you next year when I'm out here and say, you're the one, you're the one. Okay, so we've got 13 responses. Okay, so the majority of the people in this room strongly agree. We've got a few agrees, and we have a few strongly disagrees. It's my personal goal to convince you otherwise by the end of the session. We'll see how I do. Okay, so in 2001, the Nebraska Supreme Court established a Minority Justice Task Force in partnership with the Bar Association. And they were charged with looking at issues of racial and ethnic fairness in the courts. And they undertook an 18-month investigation and released their final report in 2003. And there were really three areas that report looked at. The first was access to justice. And so the committee looked at issues regarding the public's perception of fairness of the court system in Nebraska, accessibility and quality of court interpreters that we use in our system, the extent to which our juries were representative of the communities that they serve, those types of issues. The second area we call kind of the criminal juvenile realm, and what we looked at were things like disparities in arrest, sentencing, access to diversion programs, prosecutorial discretion, quality of indigent defense, just kind of a myriad of issues affecting both criminal and juvenile justice. And our third area has to do with diversity in the legal profession. So at what rate are minorities entering the legal profession? You know, are they entering law school? Are they matriculating through law school? Are they entering the profession here in Nebraska? And what's the diversity of our judicial workforce, from the judges all the way down to the clerks? That report that was issued in 2003 had nearly 70 specific findings and recommendations in regards to race and justice issues here in Nebraska. But the primary recommendation of that report was to establish a standing committee to implement the recommendations. And so the committee moving forward has really three goals: to ensure equal access to the justice system, to address racial disparity in both the criminal and juvenile justice systems, and improve diversity in the legal profession. So over the past 12 years, the committee has continued really this research or data-driven approach. And today we're going to be talking about some of the reforms that have taken place regarding racial and ethnic fairness issues in the state of Nebraska. So you might ask yourself, how does one go about, improving equity and fairness in the court system? And the way I like to talk about this is to just give you an example of the different the committee has used over the last decade. So we do this through Supreme Court rule, we do this through internal policy reform, we do this through what I call programmatic initiatives, and we do this through legislative reforms. I'm just going to give you a few examples of each. The first one I'm going to talk about regarding Supreme Court rule changes has to do with court interpreters. And so I just want to kind of poll the room here and ask you, how many of you, if you've used an interpreter for a court proceeding, press A for true, press B for false? We'll see how. Yep. Okay, so the majority of this room has used a court interpreter here in Nebraska. Here's a little question for you. How many languages are spoken in our state court system? Press A if you think it's between 10 and 20. Press B if you think it's between 20 and 30. Press C between 31 and 40. And press D for 40 or more. And it looks like everyone's had a chance. Okay. The majority of you are clicking 10 to 20. The correct answer is D. We had 41 languages spoken in Nebraska's court system last year alone. That number is growing every year. So for those of you that have used a court interpreter out here in the 12th district, what languages are you primarily seeing? Spanish? Any others? Marshallese. I haven't heard that. Where's that language from? Do you know? Marshall Islands. Okay. Well, that's great to know. Okay. So, talking about Supreme Court rule changes, in 2001, when we began our research, one of the first things we did was hold public hearings across the state of Nebraska in communities where we gave members of the public the opportunity to come and tell us what their experience and what their perception of the court system had been. And one of the major issues that we had heard about was the quality of court interpreters that were being used. So this is back in 2003. At that time, we only had 6 people certified to interpret in Nebraska's court system. So that's 6 people to cover the 93 county courts, the 93 district courts, the 3 separate juvenile courts. And so we had a lot of situations where judges were, hey, did you have Spanish in high school? You know, come on in and be our court interpreter. This is problematic for a lot of reasons. I'd like to give this example, and that is if you are on vacation in Mexico and you get into a car accident that's considered a felony, and you're in court there, would you like the person that's interpreting for you to accurately convey 20% of what the judge is saying or 90% of what the judge is saying? And so that certification really ensures that there's a high quality of both accuracy, that there's an ethical code in place by those people that have passed the certification exam. It's very important. Some of the other issues that we heard a lot about was children as interpreters in court proceedings. You know, no one else was available. There's maybe even a domestic case that children are serving as the interpreters in the courtroom. Now that's problematic for a lot of reasons. First, kind of the emotional stress that you would put maybe your 11-year-old child in by playing that role, but also because our legalese is hard for native English speakers. If you ask an 11-year-old to explain that if you violate this bench, the terms of your probation, a bench warrant will be issued, they may have no idea what you're saying. They may have no idea how to convey that to their parents. Another example, and I think this is probably the most egregious of the testimony that we heard, but we heard it in more than one location, were some instances where there was domestic violence cases. There were no interpreters available, and so the accused batterer served as the interpreter for the victim in the case. This is not how we want our justice system to operate, to be perceived. There's obviously a large conflict. So it was instances and documentation of issues such as these that prompted the Supreme Court to adopt its rules regarding court interpreters. And so among those, it created standards for quality. Our certification system was put in place. We began training people so that they could pass the exam. We prohibited the use of minors. We adopted a code of ethics for interpreters. And I'm happy to report we've really done a 180 in this area. 10 years ago, we had about 6 interpreters. Today, we have over 60 certified court interpreters in Nebraska, covering a lot of languages. One of the challenges that we still have is in these Marshall Islands and very rare languages. And we have considerable refugee populations in Nebraska. There's no certification exam. It's very difficult to find people to interpret in our court system. So we're not all the way there yet. We've made great strides. There's still a lot of work to do. One other brief example I want to give you about the effectiveness of the Supreme Court rule change is in regard to the system of bail bond. So we have situations where, especially out here in rural Nebraska, where you may not have access to a certified or even a court interpreter on a daily basis. You may not have access to a judge on a daily basis. If you have someone, for example, that was picked up for DWI on Friday, if that person's an English speaker, they can be told that if you post bond, you can get out today. If you don't speak English and no one in the jail speaks Spanish, if that's the language, That person may sit there for the weekend, they might sit there for a week until somebody can convey to them that they have the option of posting bond. I think the situation kind of escalates when that person is then told, well, plead guilty for time served and you can be out the door today. And so what the committee worked on was kind of the translation of documents, you know, advising people of their right to post bond, the procedures to do that, video recording it so that sheriff's offices that didn't have bilingual employees could convey that type of information. Since then, the committee has received, I think, 3 different grants to translate pro se forms, juvenile court forms, many of the probation forms used by our system. That's great. It's an important tool to kind of even the playing field and ensure equal access to justice. The problem with that is that our forms do change pretty rapidly, and so those always need to be updated, and so there's some challenges with that. Okay. Method 2, internal policy reforms. I've just got a few examples of this. The Administrative Office of the Courts was really looking at the diversity of their Nebraska's court system. And in 2003, when we did that initial study, there was only 1 county in Nebraska that had a staff that was as diverse as the community that it represented. Anyone want to guess what that county was? It was Scottsbluff. The Scottsbluff County, which is, I think, is wonderful. So, but the court since then has adopted a lot of different kind of internal policies to improve at least their recruitment efforts. They've adopted a pay differential for bilingual employees. They've expanded their recruitment efforts. They're working with the Latino American Commission, the Urban League, the Commission on Indian Affairs to promote openings. They revised their discrimination complaint procedures, and they adopted an EEO policy. In Nebraska, we have kind of this bifurcated system where the county court employees are state employees, and the district court employees are county employees. And so what we found is that county courts had an EEO policy in place. Many of the district courts in Nebraska did not, as you know, falling under the county, and so we were able to kind of develop a model policy for district courts and put that in place also for their protection. It's just a good thing to have in place. Any questions about that? I tend to talk really fast. Okay. Next thing I want to do is talk to you a little bit about what we would call programmatic initiatives. The Bar Association started in 2009 what's called the LSAT Prep Scholarship Program. Basically what it is a scholarship for a Kaplan course to prepare a student for taking the LSAT exam. Since 2009, we've awarded more than 45 LSAT Prep scholarships. We have a very diverse group of recipients. We have, you know, single parents, we have non-traditional students, we have people from every racial and ethnic background, including whites, just trying to kind of tap into what we would consider the groups historically underrepresented in the legal profession. The neat thing about our scholarship program is that we require the student, we require Kaplan to report the practice scores to us, and we require the student to give us their final LSAT exam. And because of that, we're able to kind of identify how helpful the Kaplan course is on the actual LSAT. On average, our students experience an 8-point jump in their LSAT from their initial practice to their final score on the LSAT exam. For those of you that have recently taken the LSAT exam more than others, you know, that's the difference between getting into law school. That's the difference between getting financial aid. And so it's been a really great program. I think one of the neatest things for me is to now see people who are in our scholarship programs, they're attorneys at Baird Home, you know, and they're donating to the LSAT Prep Scholarship Fund and really kind of promoting that to the next generation of law students. Another programmatic initiative is just really the education that the Bar Association provides. We want to make sure we have a legal profession that is cognizant of these issues, that's inclusive, that's responsive. And so we have, just for example, some upcoming CLEs. We have one on crimmigration, which is kind of the intersection of criminal defense and immigration. That's June 5th. We have a legal diversity summit on September 3rd. That's really information about how to promote an inclusive law firm environment, best practices for recruitment, retention across all levels of diversity. So not just race and ethnicity, but women in the legal profession, working across intergenerational differences within law firms. This is the 11th year we've had that program. August 19th, we're doing some CLE on understanding state, tribal, and federal court jurisdiction. We'll also be doing an ICWA update. There's some legislation in front of the legislature this session that might change some of the definitions for Nebraska in terms of the Indian Child Welfare Act. And we routinely do some CLEs on how to effectively use court interpreters because we've seen such a demand, an increase in the demand of court interpreters in Nebraska courts. And that brings me to kind of my final example of a programmatic initiative. And that is let me back up just a second. Last year, the Supreme Court did what was called a language access needs assessment. And that report showed that Nebraska is doing a pretty good job in providing court interpreters for in-court proceedings. You know, if you're going to be in front of the judge, there will be a court interpreter available. Where we're not doing very well is in the attorney-client communications. This is where we're relying maybe on children. This is maybe where we're relying on what we would call a jailhouse interpreter. So maybe your client is rooming in jail with somebody who says that they speak both English and Spanish, and you're using them to interpret, okay? And this causes some ethical concerns, okay? Do you have attorney-client privilege? Is your client actually understanding what you're conveying to them? And so it is important that you can have access to somebody who is certified or qualified for your attorney-client communications if you have a witness in the case that you need to interview. And so through a grant from the Woods Charitable Fund, the Bar Association has received funds to pilot making this a member benefit. And so if you find yourself in a situation where you need a court interpreter for your communications, not in court proceedings, you can call the Bar Association's number and we will schedule an interpreter to be available to you. They can do it over the phone. They can do it via video conference using kind of like what we're using here today so that you can view documents if you need to. And if you absolutely need it, we can try and make some arrangements to do those in person. It's absolutely free, okay? The attorney bills back the Bar Association for this service, and through the pilot, we're kind of collecting data about whether this would be kind of a sustainable member benefit to provide moving forward. Right now, we have interpreters lined up and ready in Spanish, Vietnamese, Somali, and Quiche. If you have other languages, just call. We'll try and get somebody lined up. We're constantly recruiting as those requests come in. I can also tell you that a lot of times you might be in a situation where I need this interpreter later today, and that's fine. Our interpreters kind of are quote unquote on call. And we have not had a situation yet where we haven't been able to fill something basically within 20 minutes to a half hour of posting it. And so if you are in a bind, if you need somebody pretty quickly, just call the Bar Association. Our receptionist handles the scheduling. Let her know what type of matter it is. Let her know how long you think you might need somebody, if it's a half hour or 4 hours. Let her know the language and she'll get back to you. If it's a video conference, she'll send you the link, you download it, you can be via video conference. Any questions about that? Pretty neat, huh? So just for my own guilty pleasure, I want to know how good the Bar Association is doing in promoting things like this. We've had this up and running for maybe 4 months. Have you ever heard of this? Did you know we were doing this? Click A for yes, click B for no. As I suspected, yes, no. So that's why I think opportunities like this are really important for us too, because we're able to kind of share some of the work that impacts you and that can assist you in your practice. So that's great to know. One more question on that. How likely are you to use this? Click A for very likely, B for somewhat likely, C not at all, D none, I have no use for it. What's that Bar Association doing? Great, somewhat likely, so that's good. That's good. Hopefully we'll be able to accommodate your requests. So out of curiosity, how many of you know how many certified court interpreters reside in the 12th district? Click A for 8, click B for 6, click C for 4, click D for 2, and click E for none. We got one person that doesn't want to guess. Oh, there they are. Okay. Okay. So we've got we're kind of split evenly. The correct answer is D, 2. You have Sarah Shannon in Mitchell, Nebraska, and you have Louise Sanchez in Alliance. So hopefully those names are sounding familiar to you, and those are the people that you've been using. Yes, question.
There are other people I know who tried to take the test, and even Louise and Shannon have said they did the test.
It's very hard. It's very hard. Basically, I think you're asking, you know,
Is there any thought to
yeah.
loosening up the requirement at all?
The question is, it's very difficult to pass the certification exam. Is there any thought to kind of loosening the reins on that? I think the short answer is no. I don't think that they're going to change the exam. There is a very small pass rate for the certification exam, and I think the court feels that it should be hard. They need to be able to have a very high level of accuracy for purposes of the record to ensure due process. Yeah, it is. The way the court rules are written, judges are required to first use a certified court interpreter. If a certified court interpreter is not available, they go to the list of registered interpreters, and those are the people who have that you're referring to, people who have, you know, taken the exam, they've scored at a certain level but not quite the passing level for certification. And so we have kind of the A-list all-star group up here, which is certified court interpreters, and then what I would call pretty strong group of what's called registered court interpreters. And so I would just advise you in the same situation, if you can access a certified court interpreter, do it. If a certified court interpreter isn't available, go down to that next level of registered court interpreters. There is a link on the Supreme Court's website that is a registry of all the court interpreters in Nebraska. It's searchable by district, by language, whether they're certified or registered. And so you can just go to their website to see that. Yes, question? Well, you know what? We'll look that up here at the end. That's a good question. The question was how many are registered in the 12th district. I'll get you an answer at the end. Okay, Joel.
Is that certification and proficiency in that particular language, or is it more about a test about general knowledge of the system?
Sure. The question was about the content of the certification exam. There's first a written exam. A lot of it is just the vocabulary of understanding the court system, so that they're familiar with the terms being used in the court system. You have to pass the written exam before you can do the oral part. Once you get to the oral part, there's content on there about what's called consecutive interpreting, which is someone asks a question, I repeat the question. Okay. When you're doing, there's also a test for simultaneous interpreting, which is I'm interpreting as you speak. So I'm following exactly what you say, just 2 seconds behind you. And that's a skill. That's very difficult to even do in English, to verbatim copy what somebody has said. And so most of the registered court interpreters have passed the written exam. They're still working on that really high level of proficiency, mostly with the simultaneous. I think most of them have a good grasp of the consecutive approach. Other questions? Okay. All right, the last kind of example or strategy I want to share with you has to do with legislative reform. And since its inception, one of the areas the Minority Justice Committee has been really interested in is jury service. And that's because jury service is really kind of a fundamental element of our justice system. Our case law has established that the opportunity to perform this civic duty of jury service should be equally bestowed upon all citizens. During our research, we made this kind of interesting finding, and we discovered that there was no statutory requirement for counties to periodically update their jury pool lists. And because of that, there were counties in Nebraska that had actually not updated their pool of jurors from anywhere from 5 to 20 years. Given the significant demographic change in Nebraska, you can kind of imagine what a difference there would be between the community that was living there versus who was called for the jury pool. You know, you think of a community like Wilbur, Nebraska, or Norfolk, Nebraska, Lexington, Nebraska, and you can understand why this would be problematic. So in 2003, LB 19 was passed, and it requires counties to periodically refresh their jury pool. So larger counties like a Lancaster or Omaha, they're refreshing their jury pool lists on an annual basis. Smaller counties, you know, we have some counties in Nebraska that may not even have a jury in a given year. They have kind of, it's like a tiered system, maybe 2 or 3 years for the requirement of that refreshment. So after this law change went into effect, we kind of surveyed the clerks and asked them, you know, has this made a difference? In 44 of Nebraska's 93 counties were not updating their jury pools on a regular basis. Nearly all of those counties said that it had a significant impact on who was coming in to serve as jurors following that. So we kind of counted that as a early win for the committee to be able to have that kind of impact. But we were still really inhibited from fully examining the issues because Nebraska at that time had no uniform juror qualification form. We had 93 counties, which meant we had 93 different juror qualification forms. Some of them asked questions about demographics, some of them didn't, and so there was no real accurate way to say, you know, who's in the initial pool of jurors, who's on the eligible pool of jurors, who ends up in the final jury without physically going to the courthouse, seeing showed up, watching voir dire, seeing who was impaneled as a jury. So in 2005, the committee worked to pass LB 105, which authorized Nebraska's Supreme Court to adopt a uniform juror qualification form. So we worked with the clerks of the district court, looked at the statutes, and tried to come up with a uniform juror qualification form that would meet the needs of every county. That's really not easy when you're working with 93 clerks of the district court. You guys all work with clerks of the district court. People like to do things their own way. But about a year after that, the court adopted the uniform juror qualification form. And part of the juror qualification form that you probably don't see is that there is, at the very end, a confidential juror information sheet that just asks a few questions about demographics. The clerk removes that, sends it in for purposes of research, and it's not provided to the attorneys in the case for purposes of calling the jury. And so the thought process here is that by capturing this data, we would be able to look at who's really coming into our jury pool system at these different stages. Since doing this is just kind of an interesting fact to throw in. 2 states have replicated this process. Both Pennsylvania and New York have adopted this similar type so that they could look at these issues as well. Do we have a question? Okay. Okay, hopefully we didn't lose anybody. Okay, so really this let us set up kind of a really simple research study, and that is to say, oh, I'm stuck, Elisa. My clicker is stuck. Nope. Here we go. Okay, this let us kind of set up a simple study, and that is, at that time, state law provided that the master or the source list for juries came from 2 sources. It came from voter registration and it came from driver's licenses. And anecdotally, there was some concern that because minorities are less likely to be registered to vote and less likely to have a driver's license, that we may be systematically excluding them from jury service. And so by having the data to look, we could examine the process. There may be very legitimate reasons that certain groups are more or less likely to be eligible for jury service. But if there are not legitimate reasons, those are something that should be addressed. And so we basically designed a study to compare the county population to the initial pool of jurors and to the eligible pool of jurors. And so just by definition, I want to explain what those things are. County population, we're using U.S. Census data. We exclude people who are under the age of 19 because they're not eligible to serve, and we excluded non-citizens because that's also a criteria for serving on juries. The initial pool are individuals who've received and returned a juror qualification form to the clerk. The eligible pool are the people that remain after they're removed for statutory eligibility criteria or disqualification, and those that opt out of jury service. If you are over the age of 65 in Nebraska, you can just say, I don't want to serve. You can opt out. And we'll kind of show you how that breaks down here in the state of Nebraska. Okay, so this is a table from Douglas County, which was selected because it was the largest and because we had a lot of numbers to play with, and it's a diverse county. So when you're looking at, does this have a little click pointer thing, that red one? Okay, so if you're looking at the, how to read this, the county population at that time, whites comprised 83%, blacks 10.4%, Asians 1.5%, American Indian 0.6%, Hispanic 3.9%. The initial pool in Douglas County, 86% white, 7.4% black, 2.4% Asian, 0.6% American Indian, 3.0% Hispanic. A standardized residual for, I always hear the joke that attorneys don't go into, or they go into law because they didn't want to go into math or the hard sciences. So this is your statistics lesson for today. When a standardized residual is a significance test, if that's greater than 2, it means that the difference between the groups you're comparing is statistically significant. And the larger the number that number is, the greater the disparity. And so what we see here is that whites are statistically significantly overrepresented as jurors, 5.3%. Blacks are underrepresented, Asians overrepresented, American Indians, there is no disparity, and for Hispanics, they're significantly underrepresented in the initial pool. These are the people that have returned their juror qualification form. Then we looked at the eligible pool. And what we see here is that whites are overrepresented, blacks are underrepresented and underrepresented at even a higher rate. Asians still overrepresented, American Indians no difference, Hispanics are underrepresented and they're underrepresented at a greater rate. And so we looked at this for kind of the 13 most diverse counties in the state of Nebraska, comparing these pools and these populations. What we found was that in all those counties, we were identifying significant disparities in both the initial and the eligible pools of jurors. What we found that was kind of interesting, blacks and American Indians have comparable rates of eligibility to whites. So their underrepresentation is largely a function of being underrepresented in the initial pools. So if blacks and American Indians aren't adequately or represented in the initial pool, it's going to kind of compound and you'll see that disparity in the eligible pool. Eligibility criteria have a large impact on the representation of Asians and Hispanics. Therefore, when they're underrepresented at the initial pool, they really have no chance at the eligible pool. And what I mean by this is, here are the ineligibility rates by race. So anytime a jury is called, 1/3 of whites will be ineligible, and 1/3 of blacks will be ineligible, and 1/3 of American Indians will be ineligible right off the get-go. And the black and Native American populations have kind of comparable rates to whites. For Asians and Hispanics, over half of the jurors that you call will be ineligible. Okay, so they're starting right off the go, they're going to be kicked out of the pool. And right down here is kind of the breakdown for why people are leaving, are ineligible for jury service. So for whites, the majority of whites leaving, it's opted out. These are people over the age of 65 that say, you know what, I don't feel like serving on a jury, thank you very much. For blacks, it's meeting the requirements. We have a lot of blacks in the jury pool that are not U.S. citizens, perhaps they're refugees, and so they're being disqualified for that. And we have a pretty high percentage of blacks opting out. For American Indians, we have the same. We have a lot of opting out. Sometimes we have kind of a higher percentage here of impairment, that they weren't able to serve on a jury maybe because of a disability, or we also had the issue kind of with criminal offense. if you have a certain criminal offense over a certain threshold, that could disqualify you. You'll see for Asians, though, and Hispanics, it's really populated right here in the requirement, and that is the requirement that you're either a U.S. citizen or can read, speak, understand English. In Nebraska, you're not provided with a court interpreter as a juror. Some states do that. In New Mexico, if you're called for jury service and you can't understand what's going on, an interpreter is provided for you. That's not the case here in Nebraska. So, I've got another question for you. What do you think the Dawson County data indicated? So for those of you that are from this area, you're in Chadron, looking at the eligible pool of jurors, which you've seen in your courtrooms, do you think that it showed A, no disparity, B, sorry, what did I say? What county did I say? Oh my gosh. Okay, we're skipping this question. You don't care what's happening in Dawson County. But thanks for those of you that answered. I had a few people that responded. So you can make Dawson County look as bad as you want since you don't live there, right? Okay. One of the other findings throughout the entire study was that Hispanics okay. One of the things that we were looking at, okay, we've identified these racial disparities, right? What are we going to do about it? And so one of the things the committee explored was, let's look at these source lists and how we combine them, and is there a better way to do that? And so we looked at adding state ID card holders, tax rolls, unemployment lists, those receiving state aid. Those were explored as options because they're used by other states. And so we looked at things like, would adding this list reduce the disparity? Is there a high cost in adding additional lists? Can we get the agencies to give us this information? Will adding these people just mean that we're disqualifying more people? Is it a high level of duplication with other lists? And what we settled on was looking at adding state ID card holders as a source list. And I think a lot of people, including attorneys, just assumed that if you had a state ID card, you were eligible for jury service in Nebraska, but you weren't. And it was very interesting for me that it's a pretty big group. Over 77,000 people have state ID card holders, or state card ID holders that do not have driver's licenses. So it's a really large population. And the other thing that's really interesting about this is that 90% of driver's license holders are white. 56% of state ID holders are white, which means 45% of the people that hold a state ID are from a minority, racial and ethnic minority group. And so it's a much more diverse pool that you would be adding as a source list. In 2009, LB 35 added state ID card holders as a source list for jury compilation. So we added an additional 70,000 plus people to become eligible as jurors. The nice thing about having this compilation, this process in place, sometimes when we pass legislation, we have no idea if it has its intended impact. The nice thing about this is we can measure and see if it did. So this is Douglas County pre and post. So for example, the initial pool, 83% white, the initial pool before the rule change, 86%, after the rule change, 84%, the residual 5.3. Blacks, county population's 10, initial pool was 7.4%, after the law change went up to 9.7, so this number is reduced. So you can kind of follow along here and see those impacts. But I think what's more interesting is the eligible pool. So prior to the rule change, we had an 87% white eligible pool. After the law change, 86%. I'm sorry, I guess the most interesting or way to look at this is the pre-standardized residual and the post-residual. So before the law change, we had a significant disparity. After the law change, we did not for whites. We completely eliminated this huge number, 9.7, this statistically significant difference for blacks in Douglas County by this law change. We were also able to eliminate disparity for Asians and for American Indians. Interestingly, we had no effect on the Hispanic population. In fact, it increased. And that finding is true not just for Douglas County, but for most of the counties that we've looked at. And that's very interesting. We were all clapping and yay, we've reduced racial disparity in the jury pool for blacks and American Indians. But it's always kind of puzzling why this would not have the same impact of the eligible pools for Hispanics. So we have a few theories about why this might be. First, state ID cards, obviously that didn't help. Maybe the number of Hispanics not returning their jury qualification form is growing. Maybe the number of eligible Hispanics in Nebraska is growing. Maybe we're getting more Hispanics that are not speaking English or non-citizens. Or fourth, maybe we're having using language ability as a convenient opt-out. And this kind of came from one of the clerks of the district court in Hall County. And the example she gave is that you can, when you get your jury qualification form, you can check, I do not read, speak, or understand English, and you're automatically taken out of the jury pool. And she was flipping through her forms, and she noticed on separate occasions that the people hired to serve as interpreters for the Grand Island public school system had checked that box. And she was just floored by that. Here these people are professionally paid to serve, to bridge the language gap, and they're using it as an opt-out for jury service. And so her thought was, maybe this is just the 65 plus convenient opt-out. I don't read, speak, or understand English, so I'm opting out. And unfortunately, we don't have a uniform process in place to test English ability for jurors. And so she didn't feel like she could pull this person in and say, I know you speak English, you can read this document, and we've heard that several counties handle this differently. Sometimes the judge will actually call the person in and kind of voir dire them and ask them, do you understand what's going on? And in other counties, they're just automatically excluded. And so those are some of kind of the issues that are surfacing. So this committee's been around for 12 years. Obviously, we don't have enough time to talk about all the different kind of research initiatives. Some things that we didn't talk about that I'm just going to give you the 2-second version of. We got a grant from the National Institute of Justice to look at how to reduce failure to appear. So we noticed that in Nebraska, the failure to appear rates, especially for blacks, is about double what it is for whites. And can you put kind of a reminder program in place that significantly reduces failure to appear? Just like your dentist sends you that postcard or gives you that call, that improves your appearance at your dental appointments. And court systems across the nation have realized this is an effective tool to reduce failure to appear. When you include the threat of sanctions and say, if you don't show up, these are the things that could happen to you. Not only does it significantly reduce failure to appear, it significantly reduces failure to appear for blacks significantly. We talked about court forms being transferred. The committee's been involved with juvenile record sealing legislation. One issue that I'm not quite sure has resolved itself is hearing about ICE agents who go, quote unquote, fishing for illegal immigrants at courthouses. So some counties, if they know the interpreter's coming in on Wednesday, ICE will go to the courthouse and kind of what we would call fish for people who look undocumented. We're not comfortable with this because it has a real chilling effect on accessing the court system. Are you going to report somebody for domestic violence? Are you going to show up as a witness if you think that ICE is going to be there? And it disrupts especially the civil justice process. I don't know if that's happening out here or if you guys have seen any instance of that, but I wanted to give you the opportunity to tell me if there are other issues that you think we should be looking at. Are there issues that you've seen in your courts or offices that you think the committee should address, or just comments in general that you'd like to make about it?
Is there anything talk about looking at the balance of religious affiliation in jury service?
There has not been any talk about it. It's an interesting question. I'm not sure that any states looked at that yet. Other questions? Yes.
Not a current issue, but in regards to jury research, has there been any determination that the lack of person issues is somehow correlated to defendant or state verdicts?
Oh, The question was, does the composition of the jury correlate with pro-defense or pro-plaintiff verdicts? And I don't believe there's been any research that's examined that I know of. There may have been, but it's an interesting question. I know there's been some research recently about judges and the gender of their children and how that affects judgment. So it's kind of a related, does the composition matter? Okay. That's all I have. Do we have any online questions? I want to thank you for your time. Because I'm here also as the ED of the bar, I'm going to take 2 minutes because of a conversation I had with Mike Meister to make sure you all know what's going on with the Bar Association's Rural Practice Initiative. Can you raise your hand if you've heard of this yet? Oh, great. We are going to be coming back out here in October 15th through 18th with our bus tour. We're going to be bringing students from Creighton and from UNL College of Law that have self-identified as being interested in working in rural Nebraska. We'll be setting up some interview events. We had our first interview event ever kind of as a group in Carney in February. We had 35 law firms that self-identified as being interested in rural practice. We had 18 law firms. From that event, we've placed 11 law clerks this summer and 3 associate positions. And so if you're in a situation where you think you might be interested in bringing on a summer law clerk, if you think you might be interested in, an associate, or maybe you're looking to transition and sell your practice, please call Sam Clinch at our office. He'll get you the information on our interviewing events, on the rural bus tour that's going to be out here in October, how you can get involved, and get you some information. I just texted Sam and asked him if anyone out here hired a law clerk from our event, and we have, if you know, Jamie and Simmons from Gordon, Nebraska, has a law clerk coming out this summer. Through a grant from the ABA, we're able to provide a stipend actually to the law students. So for those that have to relocate for the clerkship, we can kind of help them out with their housing costs, and that's worked really well. So, all right, thank you for your attention and your time, and I'll turn it over to, well, let's take a few-minute break, and then we'll turn it over to Joel Carney to talk about NebDocs. Thanks.
myself too. My name is Joel Carney. I'm a lawyer in Omaha, Nebraska. I've been a lawyer for 16 years now, and can't believe it. I'm originally from Scottsbluff, Nebraska, not too far down the road here. I've got a lot of Scottsbluff, 21 county pride that I love it out in western Nebraska. I primarily base my practice in litigation, so I've done a ton of civil litigation in that time. I've also done some bankruptcy work for banks and some collection work through the days through my practice. But today I am tasked with talking to you a little bit about a newer product that the bar has available called NebDocs. And what NebDocs is just, and I don't have a fancy clicker to have you vote on this, but by a show of hands, how many people have actually heard of NebDocs before today? So the majority of the room, yes. Some people say they just heard about it, but they've had a little bit of time to read them before I stood up. But for those of you online, the majority of the room had actually heard of NebDocs. But what NebDocs is a document assembly program. And it's designed to let you have a very comprehensive form set in a variety of practice areas. Currently, there's over 600 forms, and in the materials that were handed out today, you'll see the forms that are currently available, and those forms will be growing all the time and being updated on a continuing basis. The goal being that as these forms change because of statutory changes and because of just, I guess, preferences statewide, they will change, so you know when you use these forms that you'll have a accepted document in the majority of courts. Now, the other nice thing about NebDocs is it's a starting point. It's not a substitute for knowing the substantive area of law. You can't just use these forms with abandon. But what you can do is know that it's a form that was looked at by that particular practice section of the Nebraska State Bar Association. We're going to have eyes on these all the time, making recommendations for changes, and it's going to be what we believe, as time goes on, it's already a solid product, but the more we have these things looked at through the years, it's going to be stronger and stronger. Is anybody else? I'm licensed in Iowa also. Is anybody else in here licensed in Iowa? I'm the only one. But yes, I work in the river community, Omaha on the border. But Iowa was kind of the pioneer in this regard. There's been Iowa Docs since around the year 2000, and so they kind of got in on the early days of hot docs. So, does anybody, if you've heard of NebDocs, does everybody understand what hot docs is? Does anybody know what that is? So, for those of you who don't know, hot docs is the engine that makes NebDocs and Iowa Docs go. And basically, what this hot docs platform does is going to ask you questions about, say you have a guardianship that you want to do. It's going to ask you an interview, in an interview style, a bunch of questions that will in turn, after you've completed the interview, populate the forms into a Word or WordPerfect document, depending on which you use. I see even in the future, in this room there's a couple of Mac computers. The version that I'm going to talk about today is installed on a Windows operating system. I know even if you are on Mac, you're probably pretty accustomed to the Windows operating system and the tree system you can see on the left-hand side of the screen there. And what I'm going to do today is kind of demo a practice or a hypothetical case in the guardianship area of the forms, and kind of act like we are setting up a guardianship for an incapacitated person. And the goal today is to kind of show you how, after filling out a couple of forms and saving an answer file to a template, you can make filling out the subsequent forms that are going to be necessary down the line that much faster, so you can speed up your day-to-day practice and make it just that much more efficient. I've been using Iowa Docs since about 2005 when I swore in. Iowa is very similar in that they have people looking at these all the time, and there is a certification on every document saying this is an Iowa NebDocs document, so it kind of comes with a badge of honor. That's going to be something that's coming down the line with NebDocs as it grows acceptance and people know what it is. I would say that it's the number of people that know what NebDocs are in the 6,000 plus lawyers in Nebraska probably isn't the same as this. I don't think it's a 90% factor. Probably only about half the people actually know what it is. So as the word gets out, they'll grow, they'll have greater acceptance in terms of using them day to day in your practice. So what I'm going to do is I'm going to sit down, and if you can't see, you're welcome to move up a little bit, but I'm going to kind of go through a test or a hypothetical case just to kind of show you how the software operates. So NebDocs, right currently we have the practice areas that are indicated here, and basically, like I said, this is a standard Windows type of format. And I'll also remind me to slow down anytime, because the previous two speakers say they talk fast, I talk fast, and then I also am a technology geek, and so I kind of make some certain assumptions that people know what I know, and that's probably a bad assumption because I've been doing this for a long time. I was the technology guy at my previous law firm, and it's kind of a blessing and curse when you know something about technology, but I also just people usually just hand things to me and tell me to make it work. So so basically what I'll do is I said I'm going to do a guardianship. I'm going to take off my coat too because I'm sweating. All right, so as you can see, there's a tree format. Oops. Use the actual mouse. So you just punch the little plus sign that's to the left of the guardianship folder. And as you can see, I expanded this a little bit so you can see the names of the forms that are currently in that folder. There are 64 guardianship forms that are currently in this particular form set. So for purposes of this demonstration, let's say that I'm setting up I want to file a petition for appointment of a guardian. I've got a client who's come in and has somebody that needs protection and needs a guardian. So I'm going to click on this form, which is Form 60. The software automatically will ask me, okay, Mr. Carney, is this a brand new case or is this somebody you've dealt with in the past? So this is a brand new case, somebody that just came in to my office. So this is a new answer file. So I'm going to, if I had a history with this person, I could click this little down box, this down arrow here, and you would see other people that I've used on these forms or used NebDocs to build a pleading with. So this is a brand new file. I'm going to say OK. And what happens now is it's going to ask me a set of interview questions. You can see kind of the categories the questions are going to fall under on the left-hand side of the page. So first thing I'm going to do on this first one is case dialogue. So let's say that Jane Doe came into my office and she is from Scottsbluff. We want to file this in Scottsbluff County. So I'm going to choose from this drop-down list Scottsbluff County. Because I haven't filed the case yet, either by handing this person this petition I'm about to file, I don't have the case number, so I'm going to leave that particular field blank, and that's okay to do in this software. You can always come back and change it later, but also remember that the end game is it's going to populate all of this to a Microsoft Word document, and you can go in and add those things as you have that information at the end. So Jane Doe came in. We've got John Doe is going to be the proposed ward. And it's going to ask me all the questions that are required for that initial petition. So here's the next field it's asking me is the date of birth of the ward. And so you click this little calendar thing and up pops this calendar. So you can go back in time to say that John Doe was born, let's say, he was born in 1987. On May 27th. Okay, so I'll just say OK. That goes into the form. I have to sit now. The next question is going to ask me male or female. The reason why it asks you this question is because the software will put the pronouns into the form accordingly. So John is a male, And now I'm going to go to next. So when I say next, it's going to go to that next category of the left things that you see on the left-hand side. The name of the guardian or conservator will be my client, Jane Doe. She lives on 123 Garden Street. She lives in Gehring. And 693 something, 41. And she is 308 436 something something something. And she is a female. And again, as you fill these things out and as you save these, it's going to, next time I come to the next document, it'll save this information, it'll retain it. So I won't have to fill it out next time unless I find out I was wrong, that I have their phone number wrong or their address. I can make that change there, or I can always go to the Word document itself and make that change right in the document. So I've answered all the questions in the Guardian dialog, and I'm going to go next. And now now it's asking me the reasons dialog. What are the reasons that prompted this petition for appointment of guardian? In this blank, there's an example of basically a reason. So this particular one says, for the people that can't read it in the back, says the above captioned person is incapacitated and unable to make responsible decisions about medical health issues, mental health issues, and financial issues, and more specifically, he has been refusing all medical treatment, failing to take insulin. This person must be diabetic, apparently, and has had his utility bills shut off for failing to pay his bill. Obviously, this is where you start to customize the form to your specific needs, and then, but for purposes of this, I'm not going to add, for this demonstration, I'll just leave that as is. And then you can add as many functional limitations in this next category. So say that he is in a coma, as proposed ward is in a coma. I wonder why he's not taking his insulin on his own. But and you can add as many case-specific items to that, to those fields. And also, if you have even more, you can see in the dialog on the bottom of the screen, you could add rows, insert rows. If you only have 4, change it just so there's only 4 reasons. Okay, now the next one is the notice dialog. I'm going to say, okay, John's mom, Mama Doe, and in this field I'll enter all the address information. She lives in Kimball. I have no idea what the zip is down there. And the relationship, she's the mother of the proposed ward. And I'm just tabbing through these, so it just takes you to the next thing that's required. And at the end, it's always, if I miss one of these things, it'll always say, hey, Carney, you forgot what the relationship was to the proposed ward. It'll send me back at the end. Or, obviously, after I'm going to populate this to Word, you'll have the chance to obviously review that and make any of those subsequent changes. Okay, so now the next dialog is asset description. I'm going to say that he has a 1986 Dodge Dart, priceless. Oh, priceless isn't the valid number. So if it doesn't like that, I guess I'll have to give it a dollar number, and I'll say $1 million. And his estimated annual income is whatever it is, $50,000. Or that's probably estimated income. I suppose that's for an asset that actually brings income into the estate. So that probably was a field more designated for like a rental house that has income. But you'll figure it out. It's pretty straightforward. So okay, now we go to the notary dialog. This particular one, sometimes you don't know when a document's going to be signed, but again, you can handwrite that into the date if you wanted to, or you can again click this calendar. Let's just assume that they're coming to my office later today, or that I'm actually going to Scottsbluff to have her sign it. So I'm going to say, it gives you that drop down again to put in the county where the document's going to be signed. The state, you can change that obviously if I had to go across the border, go to Torrington or someplace, Wyoming, to sign it. Now we're on the attorney dialog. So again, this is a brand new version of NebDocs that was just installed on this computer. This is what it'll look like the first time you run it in your office. But assuming I had done things on other forms or otherwise, this information would already be filled out. But I'm the attorney of record, so I'm going to type in my information. Why do I have such a long address? And also, when you, nice thing if you install this within your firm, and say your assistant is running this on her computer, there's a little box down here at the bottom to select the specific attorney within the firm that she's drafting it for. So that's my number. If there was multiple attorneys, you pull up this, and again, this is going to retain all of this information in your NebDocs, and you can install that on I have it installed on my computer. I have it installed on my assistant's computer. If I wanted to, I could have it installed on my paralegal's computer if she actually did that type of work. So it's nice to have that ability with your subscription to have multiple people use the software. But if I was going to pick somebody else in my firm, I would be able to select that right here, or my assistant would. I'm going to close that one for now. And because I hadn't saved it, it's asking me for my telephone number again. Okay, so then I'm clicking Next. And that's the last question for this document, so I'm going to go ahead and push Finish. And the software says, like I told you, it says, one question is unanswered. Do you still want to send this assembled document to Microsoft Word? When we installed this, we said we had Word, so that's why if you had WordPerfect or something else, it would say, do you want to send this to WordPerfect? But I've got one question unanswered, and as you recall, it was I didn't know the case number. So I'm like, okay, fine. Let's go ahead and just send this to Microsoft Word. I say OK. Automatically Word is launched down here. You can see right now it's going to also ask me if I want to save this answer file, and the answer is yes, I want to save it, because as I told you, the more you save it, the less you're going to have to fill out on subsequent documents down the road, which is the whole goal for NebDocs, to make your lives easier for the day-to-day, the boilerplate type documentation, so you can focus on the things you need to focus on for the pleading. So this is the John Doe guardianship, if I can spell it. This is petition. It also allows you to save a description. If you have some specific things, if you wanted to say what the incapacity was, you could do that here. But for most people, if you're like me, I don't know that it has that much applicability for what I do day to day, because I try to save it. I try to name the file what it is, so I know. Yes, you have a question? This is currently saving it to NebDocs and HotDocs, and this will be on your computer, and down the road there will be an option, not too far distant future, you can also save things to the cloud if you have that comfort that you want to be saving things to the cloud. But
so this you save to NebDocs, but the other document that you saved on Word is still there.
the question was, as I'm saving this particular answer file, where is that answer file saved? And the answer is that answer file, at least in this demonstration, is saved to this computer's hard drive, or I could have it pointed at my office's shared directory. In my office, we call that the F drive, under the documents, under that particular client file. I could save that directly there. Or you can. There's also a default HotDocs temp drive that it'll save things to as you save these things. So, okay, so I'm going to say okay. I left that blank. So now I'm going to go to Word, and there's my document. And to your question kind of implied whether it was saved in Word also. You actually save this Word document that was created just like you would save any other Word document. Yes, you need to save it. I mean, right now, and it's kind of in the way at the top of this particular Word document, it would just be like a brand new document. So you would want to save it or save as. Yes, that's correct. You'd want to save it specific to a place you could find it. Right, and the question was, if say you lost or didn't know what you saved it in, or saved it as in Word, could you go back to HotDocs or NebDocs to find it? The answer is yes, because you saved that answer file, and so you can go just recreate that document if you needed to. So as you can see,
Where is this data in that on a server on HotDocs, or is it on your own?
it's stored on your computer, on the hard drive of the computer, or you, like I said, back when I saved that answer file, it asked me where do I want to save it. I just saved it to this hard drive. You could point it, just so you're uniform when you do it, you want to always save it to the same place. So if I wanted to save it to that particular client file, I could save it on our drive. The reason why I would probably do that at my office, I save them to the client file because that is backed up nightly. So if we would ever lose data, it would be backed up. But if that's your option, so it's totally customizable, just like any other. It's really very much like Word. You save it where you want to.
I save things to flash drives.
Yes.
And I don't want to do it. So you could elect not to save it.
That's correct.
You just only transfer it to the flash drive.
Yes. The question was if you were in the practice of saving things to a flash drive or a jump drive, do you have to save it to the computer itself? The answer is yes. Again, you have total control of where that answer file is saved. You could save it directly to a flash drive, to an external drive, and it would be just housed wherever you save it. So now we're on this Word document. As you recall, we didn't know what the case number was, so you can see it's highlighted there. So since it's again, we're customizing this. Since this is a brand new case, I'm just going to leave it blank and act like I'm running down to the courthouse to file it by hand as opposed to electronically filing it. I'd still probably leave it just like this in a blank. And then you just go through the document, look at it, make sure that everything fits your particular needs for that particular case. So again, it's going to bring it brought in all the statutory required language, paragraphs, and populated that based on how I answered the interview questions. So as I go through this, as you can see right here under 3, it says the proposed ward is in Tacoma. I would probably, since I didn't have looks like I didn't put a period there. You can go in there and just as long as it's going to bring that data right from the interview, and it looks like when I was talking I didn't type it well, so I'm going to add periods at a couple of these things, these items. And I go to and it's ready to go, and which obviously there'll be a little bit of a formatting issue because after you've got it set up, on my computer in the office, when I get to this point, it looks pretty automatically. But the first time you do it, you have a little tweaking to do. So I'm going to make it look the way I like it. There's a little bit of a formatting issue there. I can print it. I can save it. I can convert it to a PDF if I'm going to electronically file it right from Word, just as you would anything else. And I'm good to go. But obviously, when you initially file a petition, and I'll put the caveat out there, I don't do a lot of guardianship work. I've done a handful of them, but there's other documents that come in. I've got a question again. Yes.
The court will say that we have to use the actual form from the state.
Mm-hmm.
Now, for instance, you can't, on letters, you can't type up your own form. It has to be the state form.
Right.
So if we bring over the letters that are shown here, is that the actual state form?
Yeah, and a couple of these documents I'm going to do subsequently are the actual court-approved forms, like the order, the notice of hearing, and things of that nature. The petition is not, this one is not. Right, correct.
But these forms that are shown here do comply with the
Yes,
state.
That's correct. And I'll do a couple of these subsequent. Liz is kind of. Oh, sorry. The question was, and I'm sorry, sorry to the people that are online, but the question was whether the documents or the forms that are in the guardianship section, as well as all of NebDocs, comply with the, in this case, the Supreme Court rule on guardianships and statutory requirements. The answer is yes. Yes.
You didn't put the case number because you don't have it, you haven't filed it. When you do file it, you're not going to go into Word doc because that's not going to change anything in the future. Where do you go to enter that case number so it comes up in all future?
You can go back to that. The question was, I left a blank on this particular document because I didn't know what the case number was. The question was posed where you make that change once you know the case number, and you can do that on the next document you do, and then it'll save that number everywhere else. Or you could go back to the petition itself and just save that for the interview and just not reprint the document. But it will be saved. That case number will be saved to that template going forward. Make sense? Okay, so I'll just leave this one open for now. When I file a petition, I usually also want to do a notice of hearing and a proposed order. So I'll do a notice of hearing next. Let's see. And I'll do this in reverse order. I've just selected the order. So now, again, this is a new form. So it's going to ask me that same question it asked me on the front side. Is this a new file, or do you want to use the answer file you've already started? So I click on that little drop down. Now that I've created an answer file on this computer, I can select John Doe guardianship petition, and it's going to say automatically use this file for the next assembly if I want. I say OK. And now that I've already got an answer file in place, this interview comes up, and it already knows that it's filed in Scottsbluff County. It knows that the name of the ward is John Doe, and now I know that case number. Yes, and Liz, do you have a question? Okay. The probate case number is PR 15 10,000. It's been a bit busy year in the probate court already in Scottsbluff, I guess. Okay, so then I'm going to click next. And again, this time, this particular blank in the guardianship dialog is left blank, but okay, the appointment of the guardian is necessary because the ward is in a coma and is unable to pay his bills. And is in default, and let's see, including being in default. Start. Whatever you want to put in this dialogue. Okay, and then the next question is whether this guardianship is a full guardianship or a limited guardianship. If you click, just as you would suspect, if you push limited guardianship, the things that were grayed out down here all of a sudden on the bottom become checkable. You can actually select which things are applicable to what you want the guardianship to encompass. So let's say for purposes of this demonstration that this is a full guardianship. And I go to next. In this case, this is the guardianship 3 dialog. It's requesting information on whether or not the order is going to require a bond. I'm going to say that the court trusts me, that I know the judge, and that they're going to waive the bond, and that the guardian will need to complete the training for guardianship within 90 days, and any other particular restrictions in that last field. And now I click next, and now that I've filled this information out in the past, my name is already in as name of attorney. Now it's asking me if I'm male or female because it needs a pronoun on this particular form of the gender of the attorney. My address and all that information is already included. And now this time I got everything right. The program tells me I have not, I have got all the answers or the questions answered, and I click finish, and again, it's going to ask me that same question, whether I want to save. The answer is you want to save, keep on saving this, because the more information you plug into this, whenever it has that question, it's going to be there. So there's my proposed order. Now you see the form that the court has ordered we use in this particular instance. And again, then you can take it from here. You can add, if you know your judge's name, if it's going to be a specific judge, we can say who it's going to be. And everything else is ready to go. And again, my practice is at this point I would save it to the particular client file. So Lisa, this is Lisa's computer, so I'll save it to her desktop so she can delete it when we're done.
And I can't file it.
Yes, so she can't file it because it's proprietary to me. And these are just dialogues that are coming up that you get every time you save a document. This is a Microsoft saying, hey, you're saving this in a new file format. Is that okay? Yes. Okay. So that is, and I like I said, if I wanted to go and do other dialogues or go through any other specific forms, I know that my gal is coming in, so I want to do the acceptance. So again, pops up another question for this particular form. I say yes. Now look at all the data is going to be largely in there because all she's doing is accepting the appointment as guardian. It's all there. Now it's asking me for her email address, gdo@hotmail.com, and I send it to Word. Again, I added her email address, so I'm going to save that to that template, and I've got my acceptance, complete with the places for her to initial and all to the court requirements. So it's just, I found it to be really a great practice tool. I've used it, I'm doing an adoption. I don't do a lot of adoptions, but I agreed to do one on behalf, for the Volunteer Lawyer Project. I've gone to the seminars. I know the basics, but I also know it's an ever-changing area of the law. So I want to see the latest and greatest form. In this particular, like in adoption, Susan Sapp and others have contributed to that form set along with the people that are in that practice area. So it's a nice way that if you don't do something every day, but you're otherwise competent to do so, it's a nice place to start. And just to, again, I do like, there's so many different practice areas, and when you buy this, when you subscribe to this product, you get everything. It's not just, I don't just get the corporate or the civil litigation forms, you get everything included. A couple other things I haven't touched on. In the program itself, as I mentioned, these documents, these forms will be updated on a continuing basis as needed. If this was installed on your own office computer, on the bottom, kind of you can see where my mouse is hovering. There will be if there is updates available to any forms in any of these sets, there will be a yellow box with a little exclamation point flashing. If you click that, it takes you to the place to download the new forms, and it's a very quick process, and then you get automatically updated forms. In the future, also, if you happen to be one of those users that wants to do this on the cloud, to get your forms from the cloud, that'll be done automatically. You'll just go and you'll know that you've got the latest forms just because you're getting them. The old forms won't be available on the cloud, only the new. Let's see. You've got all the forms that are they're in the set in your materials. If you see something that isn't included that you'd like to have included, communicate that to the BARG. Sam Clinch or Liz or Lisa, we're adding forms all the time. If you see something that's a glaring omission, that's something you want to be included, you can do that. The Iowa docs is kind of it's nice for Iowa practitioners because they've been doing it for so long that there's an ability to take your own documents, because they were so early on the process, you can take your own forms and create your own forms because they have the licensing dating back that long, and you can create your own forms within that if you subscribe to NebDocs. So that's kind of nice. And we've in my office taken some forms that aren't included, like things like the letter to, like in corporate law, if you're going to do a corporation, the letter to the Secretary of State asking if ABC Corporation Inc. is an available name, complete with everything ready to go. So you can just make those things so they are included in your document set, and you can just add it to the available set of forms. So, yes, Mr. Meister.
Do you have any special software besides NebDocs?
No. When you subscribe to NebDocs, you get everything that you need to get started immediately. And the question again was, do you need any special software? The answer is no. If you subscribe to NebDocs, you get HotDocs, the player. That's all that's required, along with all the forms that are currently available that are listed in your packet of forms. Currently 600 plus, I believe.
Could you also show us the practice table?
Oh yes. Also included, you'll see there's a practice manual set, and these are being updated all the time. We've got some older things, but you'll be seeing new things all the time when you subscribe. But currently, things that I've used just because they're solid practice tools. Nice little thing you can look at is for one thing, is there's a revised statute of limitations manual. It's kind of a handy little practice tool because, as those of you know who look for these things, they are spread out all throughout the statutes, and so it's nice to kind of have a handy-dandy one-stop shop when you want to go look and see when you need to file things. The question was, can we rely on a defense? And I'll let the counsel for discipline weigh in on that. But there's all kinds of PDF documents that are seminar materials that you can go and get more information for any of these specific practice areas. And as always, you've got CLE requirements, so I would recommend that you do take all the seminars for these areas if you're going to practice in these areas. But there's just a lot of great tools within NebDocs. Anything else I wanted to show you? And there's also some links in here just to the website, the State Bar website, and just kind of some quick clicks. Question?
Can we change that form, or do we have to go in after we create a Word document back and that change each time?
The question is whether you can customize, I guess, the interview questions when you're filling out these forms to add a clause that you always use on your particular corporate entity, like articles of incorporation or bylaws. The answer is not currently. In the future, again, like in NebDocs, the answer would be, yeah, you could make that tweak. NebDocs, we got in a little bit later on the game, so you can't do that for licensing reasons. But you can obviously make those changes to your form once you get it into Word or WordPerfect. The question is, do you need a network connection or other connection to, well, you need a connection to the internet to update the forms, but the answer is if you install NebDocs to a particular computer, it's a standalone. It can operate on its own, even if you have multiple computers installed on your network. They'll all operate independently. It's really a matter of where you're saving your answer files and where you're saving your Word documents. Answer your question.
I'd like to add something about groups. I'm on the microphone. Thanks. How many of you currently use Probate System 5? A couple of you. We are converting Probate System 5 into NebDocs. That will take place this year. After this year, we will no longer be supporting Probate System 5. You'll still be able to get into it and access it, but the forms won't be updated. They'll be updated within NebDocs. This was really done for a variety of reasons, but mostly affordability for the attorney. When you use Probate System 5, you're paying kind of per are on consumption. So every time you download a form, you are charged. In NebDocs, there's a flat subscription rate. So now you'll get that, which is cheaper than Probate System 5, but you'll also get all the other areas of practice as well. And so we went that way so we could make it more affordable. But I know people that use Probate System 5, it's hard to change, and so you're wed to that. The man that developed Probate System 5 is the person we hired to do the conversion, and so we feel like we're going to have a seamless process in place for that. Another question we typically get is about the subscription and the license agreement for that. It's on an annual basis, but it's prorated. And so if you decided to sign up for NebDocs in June or July, you'd only pay for that amount left in that year. You wouldn't buy a whole year and then be asked. Typically in November, we'll give you the rest of 2015 for free plus 2016. And so there'll be some options like that throughout the year. One other comment I just want to make. Right now we offer a firm size model, and we did that largely because that's what other state bars had in place. So if you had maybe a 5 to 9 person law firm, you could buy a firm license for NebDocs. After hearing a lot of complaints from attorneys like Joel, we realize that not everyone in your firm is going to use NebDocs, and so you want to be able to purchase a license for the people, maybe 3 out of 10 are going to use it, that you can purchase licenses just for individual users within a firm, and so we're going to be offering that option later this year, if that sounds like a better fit for you. And then Mark wanted me to explain, we had this question yesterday about paralegals' use of NebDocs. And correct me, Mark, if I'm overstating this, but the paralegal is doing the work under the supervision of the attorney, doing the work for the attorney. We have no problem with your paralegal accessing NebDocs for your cases, for your files. And so a lot of times people have one license that they use, they're using it in concert with their paralegal or other support staff. So just wanted to cover those questions. Other questions? And I'll turn this back over to Joel.
If there's no other questions, I didn't really have anything else I wanted to cover. I mean, we can go through forms all day, but it's really it's so intuitive and easy to use. It doesn't require. That's the other thing I like about it. Out of the box, it's pretty straightforward, easy to figure out. And if you have questions, there's places you can contact the Bar Association with those questions, and you can get your question answered immediately. Even though I'm a techie, I don't think you're going to see a lot of problems with it. Andy in here in the office, Johnson, has installed it in his practice, and I guess maybe I'll. Can I ask you to come up here and talk to it so I can speak to the? You don't want to? Yeah. Well, I just want to updates. Yeah. Come on up. I guess go ahead. The question has been posed about updating the software. What's your specific question? Just how to go about that? It's not automatic, but again, if you're looking at your screen, if this wasn't the latest set of forms, say that there was a new document that came out in the guardianship area, at the bottom right there would be a flashing yellow triangle that has a little exclamation point in it. You click that, and it takes you to the spot to download the new forms, and then you go through a series of license questions again, just like when you initially installed the software, and then it downloads the new forms. Yes. Yes. The question was, can you go back and reinstall or go download the program once again fresh from that same place that you initially downloaded? And the answer is yes. And if you lose that email that you get that information, we can always resend it to you. Yes. The question is, does the download, is it tied to a specific computer, correct? No, not currently, and that's a nice feature because you can download it to the number of computers that are working on your particular project with your work. Mr. Meister.
So as I understand what you said, though, if you base it in the cloud,
Say again?
you said that if NebDocs is based in the cloud, that will automatically update.
That's correct. The question was if you use the cloud version of NebDocs, whether those forms will automatically update, and the answer to that is yes. And that's coming later this year. It's currently used. So say, for example, you were traveling and you had a client that needed something urgently, and all you had was your iPad, and you had a cloud subscription, you'd have that ability to access your form set, fill those documents out, and if you had Word or whatever on your mobile device, you would be able to create that form and email it back to Nebraska. Another question? Yes?
How is the software distributed for the initial setup?
The question is, how is the software distributed for the initial setup? And I think I know the answer, and she'll correct me if I'm wrong. Lisa will tell me, but at least my recollection is that I subscribed by contacting. There's a subscription form that you can access from the bar's website. I filled it out. I sent it in with my credit card payment, and after my credit card had been processed, I received an email with a link to download the software. I was up and going in about 20 minutes or less.
Then my follow-up question is, why does the subscription form request a shipping handling fee?
That is an old form that's been changed, and that will be reflected in this practice because originally it was sent to you on a disk. So
The question was, the sign-up subscription form has a space to include where you want the software shipped, and the answer to that question was that's an old form, and it's actually being updated as we speak.
the one on the website is correct.
And the one on the website is current. Another question?
There's a number of these forms seem to be updated first quarter. Are those forms not available yet? Will they be made available? Or are those forms already available yet to be updated?
I think the form that you're looking at, and I apologize, this might be what we used in the presentation at our annual meeting in October. I don't know if this is an updated form from Sam. We can post a new one on the website. Some of these have probably already been added, but this could just be an older document. I'm not sure.
Yeah, I think for the most part, they are all already on NebDocs. The one exception to that is we had originally planned to add the practice area of immigration. After speaking with a lot of immigration attorneys, they told us, don't do it. The forms change so frequently. They're already available via the federal website. If we did the immigration area of practice, we would just automate it, but then we would be revising it every month or every few months. So with the exception of immigration, I do believe those are all, and then the probate system 5 forms coming on later this year. But, I talked to Andrew at the beginning of the session. Please, if there are areas of practice, if there are forms, yesterday when we were in North Platte, there were some suggestions about not necessarily related to a practice area, but other kinds of correspondence that it would be helpful to have a template for. Maybe you're entering a limited scope appearance. Maybe it's the initial fee agreement and you'd like some sample language. If those are things that would be useful to you, by all means, send us the request. We'll add it to the list, and we'll have attorneys kind of review and put together a template for NebDocs. So we appreciate that type of feedback.
And to add on to that, I think, at least I recall in some other meetings I've had, if you're a member of any of the listservs that the Bar Association serves, there's a lot of those, you'll see questions for particular forms, and we'll kind of monitor those things and try to make those forms that are being frequently asked or requested included in future versions or updated form sets for NebDocs. Any other questions? And with that, I thank you for your attention, and thanks a lot for having us.